morning, good morning, good morning. Sorry, I was running late this morning. Belle waits till I get out of bed, and then she jumps in my spot. So this morning, I sat down on the bed next to her. Oh, here she comes. Hey, darling. And I said, come on, me have a kiss. No kiss. I said, come on, me have a hug. No hug. I said, what happened? Your cuddler's broken and you ran out of kisses. How do we get that fixed? Do we need a doggy mechanic? What is happening? It's so weird because before I got married, I always had cats, and cats kind of don't really change as they get older. Like personality wise, their personality stays. I have one hair sticking straight up right there. Cats' personalities don't really change. Like personality wise, as they get older, their personality doesn't really change. So I'm not used to older dogs. Like she's so different now. Like she used to like lay in my arms and just like look up at me lovingly, and she'd lick my face all over, and like she doesn't do that anymore. I guess maybe she's in pain and she just doesn't want to move any more than she has to. I don't know. I'm just not used to that. Cuz cats, man, cats are cats no matter what. Cats they don't change. So, anyway, that's my observations for this morning. Hi, my name is Debbie. Welcome to my channel. I do true crime videos and I stream trials, and we have been watching the Phil Spector trial from 2007 for 5 months. That's a long time, y'all. 5 months. And I am ready to be done with it, but my tech's ready to be done with it too. Let me just put it that way. I thought we were going to get through this, last week? No, we did not. Let's see what Judy has for us this morning. Christopher Plord is now a Superior Court judge in Imperial County. What is that? CAHE was appointed. He was appointed. Where'd the CH come from? CA come from? Oh, I see. I'm reading it wrong. Christopher Plord is now a Superior Court judge in Imperial County, California. It's early. It's early. I'm sorry, I can't read. He was appointed by Governor Brown in 2011. Plord has been... I got it, Judy. Plord has been reelected twice. While a judge, he initiated and built the mental health court. Oh, cool. That's cool. That's cool, because that is absolutely something that's needed. Because I think a lot of times um, it's just mental health issues when people get in trouble. It's because of their mental health, and they get put out on the street because they can't hold down a job. They don't have the money to go get treated, or it scares people. Like, I've got a very good friend that I went to high school with, and I swear the man has schizophrenia, but he was never diagnosed, and he was a stoner back in high school anyway. And so now he just self-medicates, and when he gets to the point that he needs to be hospitalized, his family will Baker Act him, and then they just work on the self-medication issue, and they don't even just touch the schizophrenia. This man, he thinks there's people in the trees watching him, and he tore all the eyes out of his granddaughter's stuffed animals because he thought there were cameras watching him. And he is, it used to be when he was, the sweetest, nicest. That's a horrible, horrible disease. And um, he's actually very fortunate that he hasn't been in more trouble than he's been in. Oh, Judy, you're fine. That was me. If I had been awake enough. Well, it did. I got it. I got it. It just took me a minute, but I got it. Okay, so let's try to finish this thing today. It's been a good trial. I've enjoyed it. I'm just ready to be done and move on to something else. And by the way, the poll results. Um, 41% was Betty Broderick. Broderick. I can say her name, Betty Broderick. And 36% was Daryl Brooks, 14 Grant Amato, and 9% Chandler Halderson. So we're going to do Betty Broderick. Last night it was Daryl Brooks. I was like, woohoo! Only because it is on YouTube. Hang on, I gotta take care. Sorry about that. So the problem, Shadow got me again. There's not a problem. I shouldn't have used the word problem. StreamYard and Court TV's website do not like to play well with others. Play well with others. Play well together. It is too early. I can't talk yet. Or read. StreamYard and Court TV's website do not like to play well together. And we have a lot of technical issues. And Betty Broderick is on the Court TV website, which is fine. It's just that we're going to run into the same issues. Hey, Jennifer. Good morning, sweetie. Okay, so I wrote it down. I know exactly where we ended this time.
As to whether um, lessers were appropriate in this case, and even having made the decision, which we all concur.
Oh, by the way, this is outside the presence of the jury, after the jury has said that they were hung. Judge Fiddler told them to come back the next day. Aw, thank you, Jennifer. He told the jury to come back the next day and just to chill in the jury room while he discussed this with the lawyers. So that's what's happening right now. They're trying to figure out which instruction were they hung up on, Judy? Something about if they believed Phil Spector put the gun in her mouth? Something like that. So, and they're working on instructions because I think they said something about being confused about reasonable doubt. So I think they were working on instructions, modifying the instructions. Special instruction 3, they were confused on. So they are working on that instruction to try to make it more understandable, I guess, for the jury.
occurred, and I still was somewhat troubled by it, kept looking, and found Lee just the other day. Now, Lee is problematical, or problematic. It's a decision by our Supreme Court. On its face, it seems to be an absolute, but the problem is it never explains its reasoning. And that is always difficult to a trial court. The absolute is, under the facts of that case, it says it was error for that trial judge not to have instructed on involuntary manslaughter on the basis of brandishing. Now, you can look at Lee a lot of ways. You can look at it factually. You can say it is different from this case because you did have a witness who saw at some point, which was a brandishing, and you could say that's all that Justice Baxter was talking about when he wrote the plurality opinion. But then you have to look at the other side. You look at the fact that there was a completed wound, that it was a contact wound to the head, which would seem to indicate facts closer to our case. And then you have Justice Brown's dissent, or concurring opinion actually, but in the concurring opinion, she indicated she couldn't understand how the plurality was discussing brandishing because it appeared to her to be a completed act. So you have those problems tugging at each other, whether under Lee, this court to instruct on involuntary manslaughter. There's a case, although certainly any appellate case cannot overrule a Supreme Court case. It can explain it, but this is actually a case that I believe preceded the Lee case. And that's a case called People versus Lipscomb, Lipscomb. And although they are dealing with the issue of lesser relateds under Geiger, it's a very similar. The facts are shots went from his backyard to his garage, intending to close the garage door. Before he could close the door, defendant ran into the garage with a gun in hand, pointed the gun at the victim, ordered the victim into the house, and warned him he didn't want to have to shoot. The victim complied because defendant was pointing a gun at him. At this point, the appellate court is explaining the law. Absent some unexplainable rejection of the prosecution evidence, the assault with a firearm was complete. I'm the one that raised Lee. I'm concerned about Lee, and there's still another issue I have to deal with. I am not sure that Lee mandates in this case, given the evidence that was presented, that agreed upon, although the facts are somewhat unknown, but the ultimate, that Lee is applicable to this case. That's number one. Perhaps more importantly, although number one resolves the issue, under the Stouter and Jennings case, and I disagree when the defense says that Mr. Jackson is grasping at straws. I don't think he is. I noted that if you want to argue that there is a difference between Jennings and Stouter in this case, you certainly can point to the fact that there appeared to be a greater dialogue. But I don't think that's the importance of Stouter and Jennings. We'd all like this case to get resolved in this case, in the amount of time that has been spent on this case, both by us, by the jurors, by the families. I mean, this case has been ongoing since 2003. But rather than just looking at the particular facts of Stouter and Jennings, I think you take away from it something very specific, and that is at a certain point in deliberations, not at the beginning, after the jury has arrived at an impasse, to then give them offense, which in essence is what man of culpability, if you will, is in essence saying to them, in my mind, well, if you can't find him guilty on what you have, try this. And I have a problem with that. And as I believe the Supreme Court and the appellate courts have had a problem with, it's not so much the words, it's basically the timing when they've reached an impasse, and to say, okay, if this doesn't work, we'll give you this, because it's basically indicating to the jury, we want you to come to a verdict, and we'll give you this other option. And the only option, the option is an acquittal. It's conviction of a lesser offense. And I think that falls within the prescription of what Stouter and Jennings say. So on two grounds, I don't accept the notice argument, but I do accept that it would be inappropriate at this time to instruct the jury with a new offense, that being the lesser offense of manslaughter, because I believe it's basically directing them, if at all possible, that's what they should find, and that is inappropriate. And number two, I'm not sure that Lee applies. It's problematic. It's sort of a 50-50 proposition. I'm not concerned in this case if there was if the jury is able to arrive at a verdict after we take other steps to assist them, that it's reversible, and it's not reversible because it's invited. It can't be any clearer.
No, the court made a good point with regard to the invited error.
I mean, if ultimately my concerns about Lee, which I'm sort of against my concerns, if you will, are borne out if there ever were to be a conviction and an appeal, that's not going to result in a reversal. That has nothing to do with my opinion. I'm just basically commenting on your comments. Having resolved that issue, that I'm not going to instruct the jury on manslaughter, there are now other issues we have to face. And that is, and I do want to hear argument on this, this is the issue of that instruction number 3. Special 3. Because, again, I'm going to reiterate, it is not a correct statement of the law, which sounds funny, statement of the law. It's a correct statement of the law based upon what they argued to the jury. But in general, there are other ways you can get to a correctly stated by the instruction 2 different times until finally in the third version, and I asked the people and they didn't have an objection. The actual language, if we don't have a strong objection, and there was no specific objection. I want to talk about whether, and this is merely, we are having an intellectual discussion at this point, the appropriateness of either changing instruction number 3 or withdrawing it, which is appropriate under the law if I determine it's improper.
Your Honor, since we're going to have an intellectual discussion, could we get the intellectual perhaps on the speakerphone? And this is Mr. Reardon's instruction. He's very familiar with this area of the law.
Fine.
Could we take a minute to try to...
We'll take a short recess. All right.
Another
We have 14 session.
Can you hear us?
I can.
Judge, we have Professor Reardon on the phone here, so we're all set. He'll handle this.
The parties are present as heretofore, and the spirit of Mr. Reardon is with us. We are going to proceed with, in light of the fact
and everything was going so good. I put a comment up and nothing happened. It didn't buffer.
sort of went on to other things about my concerns, whether that is a correct statement of the law as opposed to a correct statement of the facts as proposed by the people, and whether anything further should or could be done with it. So I'll hear any argument that anyone wishes to make.
Mr. Reardon, did you hear that? Dennis?
I mean,
I could just very briefly state our position.
all right.
To simply this, we continue to believe that the instruction was completely appropriate. So the Supreme Court has said that the defendant is entitled to a pinpoint instruction which states his theory of defense and relates it to reasonable doubt. Mr. Spector, they would prove Mr. Spector had placed the gun in Miss Clarkson's mouth and shot her. And indeed, that was the position that they maintained at the very end of their closing argument when they incorporated that position into the animation. You'll recall that I objected to the animation because it didn't appear to me that the animation appeared to have the gun, as Ms. Clark assured us, that those who had put the video together had placed the gun in the mouth. So it remained their theory of guilt right up through the final minutes of their rebuttal argument. So we think that the instruction was correct, but putting that aside, and certainly this was a case that was tried on the theory that as the animation showed, Mr. Spector has his hand on the gun and has it in Miss Clarkson's mouth. It was tried on that theory. The instruction reflects that. But in any case, at this point, after a very strong deadlock has been declared, it would seem that it would be impossible to withdraw the instruction without sending to the jury a message that jurors, I gave you this instruction, and there are some of you clearly who has relied on the instruction in articulating their position and holding to it. I am now informing those of you who relied on the instruction that I gave you that I disapprove of the position that you are taking, and therefore you should withdraw and retreat from that position to the extent that it relied on the instruction that I gave you. I think it would be a very, very powerfully coercive message that the court disapproves of a particular position taken by some group of these jurors, and at this delicate stage of the deliberations, I would submit that it would not be appropriate to inform the jury that you're withdrawing the instruction.
Thank you. I would indicate before I hear reply from the people, there's a case, an appellate case, People versus Nelson at 58 Calap 4th 193, which answers Mr. Reardon's concerns and says that it is not inappropriate if the jury is confused by an instruction that is later the court determines to be not applicable or inappropriate. So I'm not concerned about sending a message. I'm concerned about whether the instruction is proper. Mr. Jackson or Mr. Dixon, I'll hear from you again, Mr. Bruno.
Yeah,
Go ahead. It does make any difference what order.
I just wanted to expand a little bit. The record should be clear that one juror made an ambiguous comment about instruction number 3. And I don't recall exactly what it was, but it expressed some concern on some level.
Which is why I said that we may need further clarification.
Right. I would say that's certainly true, because and the other thing is that the court has said that the instruction may be too narrow under the facts of this case. And
no, too narrow under the law, not necessarily on the theory that people are putting forth. What I'm concerned about is that there are other possibilities when you talk in the abstract or generally under certainly which second-degree murder could be committed.
Yeah, well, that's where I was going with that. In general, there are numerous ways it could be committed, but when you tailor an instruction to the facts of the case, the applicable law to the facts of the case that are presented to the jury. What happens in every Sears pinpoint instruction. In this particular case, there does not appear to be another way to get there. We have been trying to brainstorm what other, with the fact of this case, find Mr. culpable of second-degree murder, other than that he did the killing. And finally, Your Honor, just if I may.
Certainly.
There is a federal case that talks about the due process implications of changing instruction after a jury has been instructed, that changes the emphasis of the overall instructions. And since this case, this instruction is at the heart of our defense, I'd ask the court to consider the case and the principle it stands for before doing anything that would change the emphasis of the instruction. And the case is United States versus Wander, W-A-N-D-E-R. It's found at 601 Fed 2nd, 1251, and the applicable language begins at page 1260 of the Circuit, Your Honor. Okay. But if memory serves, it is talking about a due process analysis, so that would be applicable in the Ninth and everywhere else the Constitution applies.
Thank you. Mr. Jackson and Mr. Dixon.
Thank you, Your Honor. With regard, I think the best indication that the instruction should be seriously considered, or there should be serious consideration to having it withdrawn, is the fact that it's confusing. We objected to the special instruction to begin with. The court indicated that it was inclined to give it and instructed the defense and us to kind of come to an agreement, if we could, about the language. We went back and forth, and there was language in the instruction that I was never comfortable with, and I generally objected to pretty consistently until Mr. Reardon finally, I think, drafted the last iteration of the instruction, which is the one that was presented to the jurors. And I was, like I said in my original arguments, it was my position. I wasn't convinced. I don't think Mr. Dixon was convinced that this was necessary. It's something Sears does give, in certain circumstances, it does give the trial court the authority to give a pinpoint instruction based on the defense theory that they wish to proffer. That's not what this instruction really does. It focuses on the prosecution's theory, and I've thought from the beginning that it heightens the burden on the prosecution. Now, Mr. Reardon focused on what our theory of the case is. Our theory of the case is exactly that. It's a theory of liability, and our argument, our animation, et cetera, and the 4 hours that I argued and the hour and a half that Mr. Dixon argued, those are theories that we have proffered that we believe the evidence supports. That doesn't mean that any or all of the jurors have to buy that theory or a theory that we proffer. The problem with jury instruction, special instruction number 3, is it pigeonholes us, which is what it did to begin with. It pigeonholes us into a theory, and it then pigeonholes the jurors into a theory, which is why the defense wanted it so badly, because it narrows all the possibilities to this, and the jurors have just indicated this is unclear. All of the other necessary instructions are included elsewhere in the packet. There's no requirement that the jurors be told what our theory of liability is. They can adopt whatever theory of liability they choose. They think the facts fit, be that of the defense, be that of the prosecution, or something in the middle that they believe that the facts support.
I think what needs to be done, let me interrupt you. Okay. I really think we need to bring the jury back out and find out what problem, if anyone perceives with that instruction, and see if there is a problem and whether anything can be done or should be done. So what I'm going to do is I'm going to bring the jurors back out, we'll bring the office back out, and I'm going to inquire. All right?
Your Honor?
Yes, Mr. Reardon.
One comment that would be very important, very brief. I can't be absolutely positive, but some quick research reveals that the Nelson case that the court cited, I believe, has been published by the California Supreme Court.
I'll certainly check on that, because if it has been, then it does cite other cases, but clearly it could not be cited. And let me do a quick check on that while we're bringing the jurors.
I could be wrong, but I believe that's the case, Your Honor.
I'll find out shortly. Thank you for bringing that to my attention. All right, let's get the jurors and the alternates together and see what we have. Thank you.
Court's again in session.
All right, back on the record, the parties, jurors, and alternates are present as heretofore. Ladies and gentlemen, thank you for your patience. Yesterday, one of the jurors, I'm not sure who, I think it may have been juror number 3, indicated that they believe there was a problem or that instruction number 3 was causing, or special instruction number 3 was causing a problem. Juror number 5? All right. Can you generally sort of indicate where you think the problem might be with that instruction?
Taking that instruction by itself, I think that's where some of us had a problem standing on that alone instead of the total.
If you just raise your hand with instruction number 3, is it causing any problem or confusion? If not, don't raise your hand. If you think it is, raise your hand. All right, juror number 11 has raised his hand. We know juror number 5. Anybody else having any? Juror number 8 indicates a problem. Can anyone else articulate? And if you can't, you can't. What problem instruction number 3, besides what juror number 5 just indicated? Anybody else have anything to add to that? Juror number 2?
I think some jurors may have a question about whether every element of that instruction must be proved beyond a reasonable doubt.
Okay. Anything else? Any of the language or anything else that's causing any problems with that instruction? Yes, juror number 6.
Part of the challenge is determining a weighting of the instructions against the evidence to determine if the totality of the evidence is to be weighed more than specific instructions.
All right. Anybody? Yes, juror number 10.
One of the issues is that as a jury, the agreement on the totality of the facts and what is drawn from the totality, different jurors give different weighting to the individual facts. And the totality for some is not the totality for the others because of the weighting of how the juror sees the facts. And so that's causing some discussion about whether the totality of one is reasonable to the totality of the others. And that's where the real concern is coming in.
All right. Anybody else have anything they want to offer? All right, what I'm going to do, ladies and gentlemen, yes, sorry, juror number 12.
Different issue, if I can bring up.
Yeah, go ahead.
I'm just asking.
Yes, sir.
I asked, wouldn't be so wonderful, but I just asked on some of the clothing articles, if we could perhaps maybe have those on the mannequin to view. We have photos, but to see the actual article might help us. I mean, we have several different photos of the different pieces of evidence, but perhaps the bailiff there, that's possible. I just asked for different pieces, but they said they're not evidence. I understand that. I'm just wondering.
Just as an inquiry, without saying whether it's appropriate or inappropriate, would that assist any other juror? I see juror number 5 is nodding. Okay. Somebody else, juror number 9, you had your hand up? Yes.
Yeah, back to my, yesterday when you asked me what it was that we're having, some of us having problems with.
Yes.
Not necessarily me. Was doubt and reasonable doubt.
Right.
And I think some of the jurors are still struggling with that. I think it's pretty clear to some of us and others not. And maybe some clarification and read back.
Read back of the instruction, or read back, since you have the instruction in the jury room, or read back of certain testimony?
I think just you reading it. I think was sort of, I don't know. I mean, we're at that point where...
Okay. All right. Anything else? Yes, juror number 10.
I think the clarification is the reasonableness. Is it appropriate for one side to feel, for one juror to feel that it's reasonable, and for another juror to feel that it's not reasonable? From the same facts that were presented in the case, is it, if one juror draws a conclusion that some of the other jurors may not feel is reasonable, is that one juror unreasonable?
Okay.
That's the distinction I think that we're struggling with.
Okay. Anything else? What we're going to do is we're going to discuss all your concerns and see if we can help you in any way. And since you're going to be eating in, if you will, I will tell you that why don't you hold off on, I don't know if you are deliberating or not. At this point, you're not. Okay, don't. I don't want you to deliberate. Just stay together. We'll have lunch as soon as we can. These are issues that counsel and myself have to discuss, and it may take some time before we resolve them. When we do, we will bring you out, and what questions we can't answer, we will. If there's any other instructions or something else that we're going to give you, we will. And those questions that can't be answered or should not be answered, we'll let you know. That's the best. Yes, juror number 11.
Instructions, I believe, number 3, the concerns we face are decisions strictly on the wording of that instruction only.
Okay.
Or do we take all the evidence?
Realize if Bev had done this, there would not have been a second trial. This is a smart judge.
A decision other than the wording on it.
All right, there's questions. I don't want to ask any questions of you before I discuss them with counsel. So thank you for sharing all that with us. That gives us some guidance that we may be able to assist you in your deliberations. So go ahead, keep in mind the admonition. If the jurors will return to the jury room, if the alternates will return to their secret room, and then we'll at noontime we'll get you together. And, you'll each have your lunches, and as soon as we can after 1:30, we'll try to help you with these issues. I doubt it will be right at 1:30, but we'll. All right. The jurors and the alternates have left. First of all, Mr. Reardon was correct, and I do apologize. I was given a case that hadn't been properly shepherdized, and the Nelson case itself, he published. There are other cases cited within Nelson that I want to read, and if you want, I'll give you the citations.
Judge Fiddler brought in the jurors and talked to them about where their confusion was and which instruction they didn't understand and why they didn't understand it and why they had a question about what reasonable doubt was. And if Bev had done that, there wouldn't have been a second trial in the Karen Reed case. It was still a hung jury, but he is trying to make sure he is doing everything in his power to get this jury to understand the charges and the jury instructions so there's not a hung jury. I love this judge. I think we need to clone this man and let... It's like the clone army from Star Wars. We need a clone Judge Corps and clone Judge Fiddler and let him just be the judge for every case. He's perfect. I've not had one problem with him at all this entire case. Him and Judge Darrow. We need to clone and Judge Penny. We need to clone those 3 judges.
They're in Nelson. Perhaps you're aware of them. I don't know. People versus Beardsley, Beardslee, 53 Cal 3rd, 60. There's also a case that I don't think is directly on point. It just talks about the court having not just sitting there when the FRYE, 7 Cal 4th, 1148.
I'm sorry, Cal 4th?
Yes. Let me see.
And the page? 1148. Thank you.
There's also, again, these are more general. Let me just see that. I think some of the others. are just sort of general law. So let's take a look at that and see if they're helpful. We can all take a look at that. And then make a determination as to whether 3 needs to be modified, withdrawn, or that doesn't mean just because an instruction causes jurors a problem that it should be withdrawn or modified in any way. It just clearly it is a problem. Given the fact that it is a pinpoint instruction, I think we do need to look at it. I'm happy, as indicated, to read the jurors at the appropriate time, reread the reasonable doubt instruction if they want to hear it from me. I don't have a problem with that. The answer to the question about if one juror thinks it's unreasonable and the other jurors think it's reasonable, obviously it's an individual determination in consultation with the other jurors as to whether a doubt they have is reasonable, and that's about all I can tell them and will. And I think now would be a good time, we have a little time this morning, to address the giving of the more instruction. Okay?
Does the court have our modified more?
I'd have to ask Wendy.
Oh, man.
Yes, if you have something to show me, that's fine. Thank you.
Mr. Reardon is asking.
All right. Is he, perhaps we should join hands and see if we can summon Mr. Reardon forth. All right, you with us, Mr. Reardon?
Good morning, Your Honor.
Good morning. The jurors, several jurors have indicated a confusion or problems with, for pointing out that the Nelson case was depublished. We're going to look at the other cases that are cited in Nelson and see if they have anything to offer us. And now we're talking about the propriety of giving the more instruction. So, Mr. Dixon or Mr. Jackson?
Oh,
Sorry?
sorry. Judge, this doesn't bear a whole lot of argument. This is...
Did he say, oh, that's us? It's like, oh, I wasn't paying attention. The teacher just called on me. Oops.
I think it's pretty much verbatim, right out of more. And Judge, hang on.
We did make some modifications to it with respect to the CalCrim and CalJIG instructions, and I think that's pretty clear where they're made.
Right. I was going to cite his name. The appellate courts are loath to cite trial court judges' names, but in fact, when this judge formulated and fashioned this particular instruction, the appellate court took the exceptional step of actually citing the trial judge and said you did modify where, for instance, originally the trial judge had cited CalJIG 17.40. We changed it to CalCrim instruction 200, which is the concomitant instruction. The same for 17.41, which I don't think exists anymore. We substituted CalCrim instruction 3550, which is the admonition to the jurors just before they begin deliberations. Other than that, it's straight out of the opinion.
Okay. Does the defense wish to be heard?
I think Mr. Reardon wants to address.
Mr. Reardon, do you wish to be heard?
Just this on the more instruction, Your Honor. You know, the facts and more were that the jury had deliberated only a day, and a division had not been revealed to the court. So certainly after only a day, there was no likelihood, without knowing the division, that the instruction would have a coercive effect. It has been criticized recently by the 6th Appellate District on the grounds, particularly on the grounds that the phrase that you have a duty to deliberate as long as it takes is certainly suggestive of coercive, and they've said that the court should simply give 1740, which was approved in Gaynor or give the equivalent language in CalCrim and said that one should be extraordinarily cautious of giving a more instruction. A more instruction has never been given after 5.5 days of deliberation. So we think that if the court's going to say anything is now in the general CalCrim instruction on try and reach a verdict, but maintain, your opinion as well if it's conscientiously held. So we oppose anything other than what's in CalCrim or CalJIT.
What, do you have a citation on the case?
The case that I referred to, Your Honor, is admittedly, it's a Cal Reporter opinion. A defense counsel, I believe, has it in court.
Hello, Your Honor. My name is Phone Reardon, and I am here representing Reardon, and I am a living phone on the land.
Or Wansley. It's an unpublished opinion, Your Honor. We're not citing it as a published opinion, but the discussion in both the majority and the concurring opinion of the caution to be used in approaching more, I think, is useful language, Your Honor.
All right, thank you. I appreciate it. All right, we're going to be in recess until 1:30. We can discuss these
Okay, that was really stupid, but y'all love me because I'm funny, so...
issues at 1:30. All right, thank you. No, because it's an unpublished opinion. Thank you. There may be, in any event. Thank you. I have lots of unpublished opinions that I can't rely on. One further.
Reardon's going to handle the argument, Your Honor.
Okay, Mr. Reardon?
Your Honor, correct me if I'm wrong. As I understand it, the question that remains to be decided is whether the court is going to withdraw special instruction number 3, and then if the court made that decision, what other consequences that might have in terms of instructions that need to be given.
That's correct.
And Your Honor, again, I would just reiterate that we are in a situation in which the jury has deliberated for a week within the instruction. There is, both in federal court and state court, a statute that says the instructions are to be determined before the case is argued. Obviously, we in our closing relied on special instruction number 3 heavily. It's our theory of the defense. That's why we asked for the instruction. And I do think that even if the court could have correctly rejected the instruction at the time, and I do think we were entitled to it under Sears, if it were to withdraw it now, 2 things would occur. One, it would be sending a message that jurors who have relied on it discussed it, and then there certainly seems to be some jurors who used it to buttress their position, that the court is directing them that they were wrong to do so and should reconsider. And secondly, and correct me if I'm wrong on this, the point of withdrawing it would be to say to the jury that I told you that there was one theory of the prosecution here, a gun in the mouth with Mr. Spector's hand on it, which was the theory that they expressed in their animation. And the court is now saying, by withdrawing it, I'm suggesting to you that there are other factual scenarios which might support a murder verdict. And I don't know what those are, but to inject them at this late point in the proceeding, I suggest, Your Honor, would simply not be fair in terms of changing the focus of the trial after all of the evidence and argument is in. And that's I submit it both as under state and federal constitutional law that it would be improper. I do have comments if the court should decide that it is going to proceed in that direction as to what other instructions might need to be given.
Thank you. People wish to be heard.
Your Honor, I think Mr. Reardon said it exactly. This instruction pigeonholes the prosecution in a position that it shouldn't be in. Ultimately, it was the reason for our objection to the instruction to begin with that it requires the jurors to find something that legally they are not required to find. This heightens our burden and narrows the theories of liability, within which they are, the framework within which they are allowed to work. They're allowed to determine what theory of liability they think is most appropriate based on the facts that outright or wholesale. They don't have to follow the defense's theory of liability or their theory of defense. They can reject that outright or wholesale. And they can garner the facts or corral the facts as they see fit and apply them to the rest of the law as it applies. The problem with Special Instruction 3 as it was originally drafted is it doesn't give the jurors that ability. And the best proof is in that pudding sitting in the jury box when as a matter of Special Instruction number 3. In fact, one of the jurors said, do we have to follow, or do we have to, does the prosecution have to prove each element of Special Instruction number 3 beyond a reasonable doubt? There are no elements in Special Instruction number 3. The only elements that we have to prove, and we'll get to this discussion and the discussion of the jurors' questions in a minute, the only element we have to prove are the elements of murder, second-degree murder, beyond a reasonable doubt. And the only other thing they have to find beyond a reasonable doubt is the defendant's guilt. They can use the facts in any way they deem appropriate. And there are several different theories that they could use that are not consistent with or variations of the theory that we presented. That's why we think that Special Instruction 3 shouldn't have been given to begin with. And there is reason, there is logic in withdrawing it, to remove exercised over these. Inclined to withdraw it outright, we have drafted what we believe is an appropriate modification of Special Instruction number 3. I have a copy here if the court wants to see it now, or if you want to wait until further arguments.
I'm prepared to rule without seeing that instruction.
Okay.
Anything further, Mr. Reardon?
Not on this issue, Your Honor.
All right. Spent a great deal of time rereading Special Instruction number 3. It is clear to me, at least in part, and I mean nothing negative about this, it's an observation, is why the defense fought so hard to get this in, because it misstates the law. And the misstatement of the law is in the final sentence. If you do not find that the prosecution has proved beyond a reasonable doubt that the defendant committed that act, which refers to the theory that the people have used, that you must return a verdict of not guilty, is not the law. That is simply not a statement of the law of second-degree murder. And it is absolute error. It is just wrong. And it's no doubt, I can see why the jury is confused. So I am going to withdraw Special Instruction number 3.
If it's wrong, why would you let it go back to the jury in the jury instructions? Didn't you? Okay, maybe I was wrong about him being perfect. Did you not look at that before it went back? You okayed it. You have to okay all of the jury instructions. And now you're saying that one was a misstatement of the law. You okayed it. No wonder they're confused.
Will inform the jurors that it is being withdrawn because I believe it is better covered in language in other instructions without highlighting it to any degree or telling them that I disagree with it, or what the defense has relied on Special Instruction number 3. I will allow the parties to re-argue as to that instruction, and anything that covers it covered by that instruction, and you may now re-argue the case to the jury as appropriate. It's that simple. As simple as anything can be. Now further, so I don't know that we're going to do that today. I think you're probably going to have to rethink how you want to do that, and I think that's appropriate that we probably do that first thing tomorrow. There are other issues that we need to deal with. The defense, Mr. Reardon, you have submitted a unanimity instruction, which I have, I don't know if the prosecution has received it.
No, we have not.
Okay.
Your Honor, nor with that.
Okay, this came supplied if where I could reach.
We went through the lunch hour, tried to articulate. We heard the jurors say in their questions and came up with some suggested ideas.
Have you shown that to the defense?
We'll give it to them right now.
Okay.
I'm going to hand these.
Oh, yes. And the problem I have without, and certainly I'd be glad to hear argument, Mr. Reardon, is that it seems to contravene the law. I suggest that you look at the use note under 3500 of CalCrim, and which is the unanimity instruction, and it specifically states, let's see, or at least it's stated in one version I have to take a look at, I have a different volume on the bench. In any event, I can see that the use note has changed to some degree. It's the difference between different theories and different acts. So I would like you to address that if you would.
Yes, Your Honor. And let me anticipate, perhaps correctly or incorrectly, some of the court's thinking, because this unanimity issue in the context of murder charges has been quite sticky. The that has controlled everything since it was decided is a case called Shad versus where it had to decide whether you could go to a jury in a murder case on two theories, one being that the defendant was a direct participant and the other a felony murder theory. The decision came out 5-4, saying that you could both go on felony murder and on a direct killer, direct participant theory. But the vote was split 4-4, except for Justice Scalia, who wrote and said, frankly, it wouldn't make a lot of sense to say that you could have those two different theories, and you could say that it's unanimous if the jurors split on them, except that's the way it was given felony murder when the Constitution was enacted in 1789. So since then, courts have been trying to figure out the implications of Shad, and we would simply say this, that the original instructions, the one that the court is going to withdraw, said that there has to be a situation, the prosecution has to prove that the gun was in the mouth with Mr. Spector. The court is necessarily saying that on Mr. Spector's part, other than having the gun in the mouth and being when the fatal shot is fired, that could result in conviction of second-degree murder, which opens it up to theories a misdemeanor, and somehow that brandishing led to a fatal shot in the mouth, even though Mr. Spector didn't have his hand on the gun, because of course if he did, we wouldn't be having this discussion to begin with, or a particularly ill-informed law publication article said, well, maybe he gave the gun and encouraged her to commit suicide, for which there's not a shred of evidence in this record as a possible theory of liability. But the point is that we are now talking about very, very different acts, one of which is the one the prosecution has always maintained and of which some jurors are convinced, that is to say, that the gun is in the mouth and Mr. Spector is holding it. To say that there is a unanimous finding of guilt if some jurors thought that Mr. Spector never even brandished the gun, but might have put it in the vicinity of Ms. Miss Clarkson when she was intoxicated and therefore should be criminally liable on that theory, or brandished the gun and somehow it got into her mouth without his placing it there. You just have very, very different factual predicates. The cases that we've cited, Gonzalez and so forth says, and I think the court has these citations, the unanimity instruction is required if jurors could otherwise disagree which act the defendant committed and yet convict him of the crime charge. And on that basis, Your Honor, we do submit that the jury would have to be unanimous on what act of Mr. Spector caused the death of Miss Question. Mr. Jackson just said that special instruction number 3 is that he committed an act that caused the death of Miss Clarkson, and there would have to be unanimity on that factual predicate, or else we just don't have the kind of unanimous verdict that the Constitution demands.
All right, thank you. Thank you, Mr. Reardon.
Your Honor, that, once again, the wording of the proposed unanimity instruction has exactly the same flaws that the last sentence of special instruction number 3 has. It's not the correct statement of the law. If Mr. Reardon's concern is that Mr. Spector could be convicted because he just, I don't know what he said, just something about placing the gun on a table or something, and some juror found fault with that. He forgets that the jurors were instructed on and can be re-instructed on Calcrim 520. The defendant acted with implied malice if he did the following things: intentionally committed an act, the natural consequences of which were dangerous to human life. At the time, he knew his act was dangerous, and he deliberately acted with conscious disregard for human life. There are the elements. That's what we have to prove, and they're told in the instructions they must be unanimous when they come to their decision that these elements have been proven, and they must be unanimous about the defendant's guilt ultimately. That's the only thing that has to be proved beyond a reasonable doubt. The facts do not have to be proved beyond a reasonable doubt in and of themselves, only the elements of the crime, and ultimately the jurors need to make a determination that the defendant is guilty beyond a reasonable doubt. They can, and often do, use different theories among them to come to these conclusions. This unanimity instruction takes away their ability to utilize different theories if they see that different facts fit different scenarios in different ways, and that's simply not the law.
Okay. I have a couple of questions. First of all, does the defense wish to re-argue the case in light of if the court withdraws special instruction number 3?
I think maybe we have a moment.
Yes, you can have more than a moment if you need it, because that raises other issues as to what the people may then argue.
Okay.
Yes.
We need to know how the rest of these issues are going to play out. There are some quasi-questions pending by the jury, and we need to know whether that unanimity instruction or some other unanimity instruction is going to be given. So could we not answer that question?
Yes, and I need some time to think about the unanimity instruction. I want to take a look at some of the cases. Another issue, which I just alluded to while you were having your discussion, is if the argument is reopened, it then raises a question, and Mr. Jackson, I mean, people have been throwing around the term brandishing. We're not going there. If we get into brandishing, then the court's going to instruct on manslaughter. I can tell you that right now, despite my earlier ruling. You can't go there. Right. And the people, therefore, when we talk about if you choose to argue, and of course the people argue, you have to be very careful about what acts you allege can suffice to support the murder charge, because depending upon what you argue, you may well open up lesser. And that's just a fact.
And I've known that. Mr. Dixon has known that since the time immemorial. Okay. Since we started this case.
By the way, to send the jury home now rather than keep.
I don't mind, because we're not going to get to them today. I tend to agree. We need a lot of things. We need to discuss a lot of things. I need to look at some cases. So the chances of reaching them today are practically nil, and I think it's a good idea. So we'll get the jurors and the alternates out, and as soon as they're out, I'll send them home, and then we'll continue our discussion.
Thank you.
Okay.
Court's again in session.
All right, back on the record. All parties, jurors, and alternates are present as heretofore. Ladies and gentlemen, tomorrow, and we're not going to be able to do it till tomorrow because counsel and I have to go over it, we're going to give you some new instructions. and perhaps redefine some of your older instructions and clarify some things, which I think may benefit you in your deliberations and may greatly help you. They may not, but hopefully they will. And we're going to need the rest of the session, very important, because at this point, the media is showing great interest in the case, and I want to make sure you don't read or hear anything, so just don't. It's real simple. Keep in mind the rest of the admonition, and we will see you tomorrow morning at 10 o'clock. All right, thank you. All right, the jurors and the alternates have left. Let's pick up on the unanimity instruction. I'm sorry.
We never had a copy of it because we had submitted it to the government, so I've asked Chandra if she would just cut us some copies so we can all have our own copy. And she's doing that right now, so if you just give us a second, please.
While we're doing that, I can tell you the problem I was having. I was trying to quote the use note. For some reason, the 2006 version of CalCrim had it, the quote I was looking for in the use note. The 2006/2007 version omitted it. I just got literally hot off the press the 2008 CalCrim version, and it's back in. And I'll talk to you about what's in there. And it cites some cases, and I have one of the cases, and I think the language makes very clear what the court should do as far as a unanimity instruction.
And you don't think it's not in the one that, I've got 2006, 2007, I'm not going to find it?
No.
Okay.
For some reason, it was, whether it was by accident, because it's back, the same quote is back in the new version. But it's the case law that's important, and I've got the case for you.
The language has not changed then?
No. It's not the instruction. It was the use note for some reason that appears to have been omitted. But while we're waiting for the actual instruction, let me read you. It's not even important to read the use note because the use note refers to a case. I'm going to read to you from that case. It cites more than one case. People versus Russo, 25 Cal 4th, 1124, which is our California Supreme Court. The key to, and this is from page 1134, the key to deciding whether to give the unanimity instruction lies in considering its purpose. The jury must agree on, quote, a particular crime, close quote, and I'll eliminate the citation. It would be unacceptable if some jurors believe the defendant guilty of one crime and other jurors believe her guilty of another. But unanimity as to exactly how the crime was committed is not required. Thus, the unanimity instructions is appropriate when conviction on a single count could be based on two or more discrete criminal events, but not where multiple theories or acts may form the basis of a guilty verdict on one discrete criminal event. That seems to be exactly the situation we're talking about. So I would say, and certainly I'm open to further discussion or further cases, that based upon this, the unanimity instruction would not be given. It's not required.
Your Honor.
All right, thank you, Mr. Reardon. Based upon what the court has just read, now, I don't know if you still need more time to consider whether you wish to argue, because then we have to go into a whole, or do you want to still talk about the other jury issues first?
We do, Your Honor.
Okay, that's fine.
Yeah, please.
Since we have not read any of the other cases cited, and Gonzalez seems to be inconsistent. It's in the use note as well, I believe. It's 141 Calap 3rd.
California Supreme Court versus an old statement from an appellate court, it's pretty clear which one controls.
Well, if they're talking about the same thing. I'm just saying.
I understand.
Don't carve it in concrete.
It's not, nothing is carved in concrete. It's all quicksand.
Your Honor, I think that we would ask, and perhaps we can, we'll move out of the courtroom and do it relatively quickly. We do need to have a discussion on our position on reopening argument.
Okay.
Prior to that, and in order that the record be complete, we would submit a formal motion or mistrial based on two factors. One, our disagreement with the court's decision to withdraw the special instruction which it previously gave, and the second, which we argue in tandem and as both a separate ground and one which reinforces the first, is that but is different from what we've discussed, is that the discussion that occurred with the jurors, the colloquy based on their reaction to special number 3 and the remarks that the jurors were quite extraordinary, and they were tremendous window into the jury's deliberation. Some said what somebody feels is reasonable and others doesn't. Some look at specific acts, some look at totality, and relying on the language in People versus Cleveland, which is a case about an erroneous discharge of a juror, which obviously the holding isn't what we're citing it for. But at 25 Cal 4th, at 481 and 482, the court talks about the need to protect juror privacy. Notes, and I quote, "The mere suggestion that the views of jurors may be conveyed to the parties and the public understandably may cause anxiety and fear in jurors and distort the process by which a verdict is reached." I realize that when you get a hung jury and you're trying to make an inquiry which allows the court to determine whether further deliberations would be productive, that there's always a grave danger of stepping over the line. I think it's unavoidable, and it isn't anything the court is necessarily responsible for. I think quite a discussion and dialogue broke out between the jurors, but I think that the level of exposure of their deliberations at this point is what Cleveland counseled against. We are in a situation where after that level of exposure, virtually any direction to go back and further consider the case would be coercive. So on that ground, the language in Cleveland, as well as our objecting to the withdrawing of number 3, we do formally submit a motion for a mistrial.
All right, that motion is denied. I just read the Cleveland case. I happen to have the volume here on the bench, and the language is completely an opposite, and it does not control what took place in this case. There are any number of cases, numerous cases, wherein, because of the situation where a jury, and by the way, this jury is not hung, they're at an impasse. The jury is hung when they cannot come to a conclusion after everything is done. We're not there yet. They're at an impasse. Where a judge inquiring into what is the problem or what concerns the jurors have is able to have inappropriate in that, and just the opposite as a matter of fact. So the motion for a mistrial is denied on both grounds.
Thank you, Your Honor.
Thank you. Do you want to go over at this point how to answer some of the other concerns of the jurors?
I think we would, Your Honor. That'll give us guidance and make a global decision as to the remaining questions.
Well, the easiest one, and I know the people have submitted certain items here, but where they asked if one juror has a doubt, does the other jurors outweigh it? Of course not. Each juror has to act on their own. If their view of the evidence is a reasonable doubt after discussion with other jurors, then it's a reasonable doubt. And for that juror, that's what reasonable doubt means. It's not that other jurors disagree with he or she. Him or her, pardon me.
Was that number 7, Your Honor?
That would be on the people's list.
That would be number 7.
Right.
What I did, Judge, is I literally scribed down in the order in which the questions, the dialogue took place. I think there were 8 statements and or questions by the jurors indicating that they needed further clarification. There was one that was actually just a comment that needs no further clarification.
Well, we can take them in the order you've listed them. Let's just do it that way.
Can we do this, Your Honor? Because Mr. Reardon doesn't have this copy. Can we read the question so that...
Okay, I'll be happy to. Question, whether the instruction should be taken by itself, and it should be instruction should be taken by itself instead of taking all the instructions as a whole. Since 3 is being withdrawn, this no longer applies.
Well, no, it may apply. Right?
How so?
Well, we're assuming that only 3, that question applied only to 3. as a general proposition, all of the instructions should be taken in light of the others, depending facts are.
But that's already, they've already been instructed on that.
All I was going to suggest is that we remind them of that.
No, I don't have any problem with that.
We indicate one instruction, has the court made a determination, or do you want to discuss this after we talk? It doesn't make a lot of sense, because I think the more instruction does answer several of the questions that are posed.
I am leaning strongly towards giving them more instruction.
Okay, assuming that that's the case, when I reference more instruction, all I'm saying is I think there is language in the more instruction that answers that question, and Mr. Brunon would probably be satisfied with that as well, because it does specifically state that all the instructions are to be taken as a whole as well.
But actually, I don't think that we're at the point where the more instruction is necessary or appropriate.
It may be if the instructions, and that's, I said, I'm leaning, and we have to wait and see. We haven't had arguments. So in any event, as to number one, I will definitely see that they are instructed on that.
Number 2 is no longer applicable.
Okay? That had to do with special instruction 3, which is now out. Question 3 is whether in determining the weight of the evidence, the totality of the evidence should be considered, or the weight of one specific instruction that is contained within the jury instructions. Right. Again, but
I think one will answer. The answer to one will answer that.
Okay.
We agree.
All right. Question number 4, different jurors are giving different weight to different facts because the totality for some is not the totality for others. Well, they may do that.
And that was just a comment, I think.
Existential. The reality for some is not the reality for others, and I think that that's probably, we should say that's true.
It's okay.
Your Honor, I don't think you should touch that one with a 10-foot pole.
Mr. Reardon has raised the defense of 10-foot pole. Does anybody wish to be heard on that?
We agree.
Okay, so just don't respond. All right, that's fine. What about a 9-foot pole? I mean, no,
Not even a 1-foot pole.
all right.
Leave it alone.
Number 5, question whether the jurors can view the clothing articles on a mannequin. That's something we had not yet discussed.
I think we just need to say.
They're not in evidence.
Right. They've got the pictures. They can refer to the pictures.
I think that's appropriate. I think it agrees that the incident is in the same condition when either it was on the day of the event or when it was, or they were reviewed by either any of the experts.
Would you like me to comment? Because I think the jury, well, you might want to think about this. The defense is rapidly shaking its head. I think what you're liable to find is that jurors are liable to make some inferences. Oh, somebody's trying to hide this from us. If you make a comment as to why it's not being shown, I think you'll find that both sides are in much better shape.
What did you have in mind? Something along the lines?
Something like, you've asked to see the evidence. Incorporating the evidence is no longer in the same condition as it was originally, plus which those items have not, the items are not in the same condition, and they are not in evidence, and the law does not permit you to view things that are not in evidence.
That would be our request.
Okay, all right. Question number 6, jurors are having problems with concepts of doubt and reasonable doubt.
Our position is we'd like to open argument for that.
Well, we're going to see. Obviously, that's an issue.
The reference to that would be reasonable doubt instruction to try and improve it or elaborate on it.
Well, I take your 10-foot pole, your 20-foot pole, and your 30-foot pole, because the bottom line is any judge who tries to reword the reasonable doubt instruction is really looking for trouble. I'll try to be in very temperate terms. I have a lot of other things I could say, but the bottom line is that is not to be done. And since one of the jurors at least has asked that I reread reasonable doubt, I will do that.
But you're going to hold in abeyance any decision about allowing us to re-argue that particular issue?
Yes.
Okay.
Yes.
Is that the only question that we would re-argue?
Well, we'll talk about that. We can go through the questions here. Number 7, whether it's appropriate for one juror to believe a fact is reasonable while another believes the fact to be unreasonable.
It's really a lot like 4. I mean, it's just...
Okay.
That's how we started our discussion.
Right.
That's the first one that you thought of. I think that's answered by the more instruction and no specific pinpoint to this juror. This question needs to be asked or answered.
And question number 8,
Is not applicable.
is not applicable because it dealt with the wording of special instruction 3.
Correct.
All right, now you want to discuss how far argument could go if the case is re-argued? Is that where we're at now?
If you could give us some parameters before we present our position.
Roger?
Yes.
I think that on this and articulated to the court before I think let's convene and take a position on whether there should be argument.
Could we,
Would you like to take a break and convene and proceed if there is a position on argument?
I think that would be appropriate. Yeah.
Okay, why don't all right, we'll take a recess. Thank you. Okay. Let me just say this before you convene. If the parties come to some agreement as to how much they want to re-argue, I'm fine with it. Doesn't make any, I mean, if you come to an agreement, you're going to get it. If it comes to where we don't agree and we think it should be limited to this or this and that, then I'll make a decision. But the bottom line is, if you can come to some agreement, we need to argue A, B, C, D, and E, and we think that includes now, X, Y, and Z, I don't have a problem with it.
Your Honor, could the court mark the little summary of the questions as a court's exhibit, make it part of the record, please?
Can someone give us maybe an unmarked version of that? Supply the clerk with that. I have notes on mine.
I've got one ready.
All right, we'll be in recess till I hear from the parties. Thank you. And alternates are not present.
We're just waiting for Mr. Reardon.
Okay.
I'm on the line.
All right. And who would like to?
Discuss this among counsel and with the defendant, and our position is as follows. The court has made the decision to withdraw special instruction number 3. We've made our mistrial motion on that. We consider that matter submitted and closed. But the court, in doing so, said some things that I think are relevant to the present question. I said, Your Honor, I think that if you withdraw that instruction, you're clearly sending a signal to the jury that those who have relied on it must now reconsider their position. You're essentially telling them that their reliance on the prosecution's failure to prove that specific fact must be reconsidered, and you're directing them to do so. And the court said, no, to the contrary, the way I'm going to frame this is simply that the addition of special number 3 was unnecessary. This case is controlled by the general principles that I've given the jury, the general instructions generally drawn from CalCrim, and I will not in any way draw special attention to it, head on it, or wrong, or reconsider their position. So the court is essentially saying that once I withdraw it, they'll have the law under saying general legal principles which are appropriate. The evidence hasn't changed and the law in essence hasn't changed. And given that that is the case, we absolutely and strongly feel that there is no basis whatsoever to reopen argument, and that the reopening of argument can only result in the complete perversion, if you will, of the instruction that the court is going to give them, which is essentially ignore that, it's unneeded, no big deal, controlling principles apply. Because this is a situation, and Mr. Jackson said something extraordinarily important this morning when the court put the question to him, why didn't you ask me for lesser included? And he said, we made a tactical decision, and I think that we now regret it. They made a tactical decision to present their case on a particular theory. They presented it, and quite able piece of animation at the closing of their argument, and there the matter is lost. Without any significant change of law, they would now be saying, wait a minute, we're a week into this. We have just heard the jury give this extraordinary, sense of where the fault lines may lie. We have a sense of what the division is, and we now know that the theory we propounded tactically isn't working. And my God, for the first time in the annals of American jurisprudence, we are going to get a chance to take all that information from the jury and argue our case.
He just said this is the first time this has ever happened. But Judge Fiddler said it was legal, that they were allowed to do this. So if there's no precedent, why is Fiddler saying it's okay to do this if there's no precedent for it? Thank you, Judy, because I was wondering what the Moore instruction is. So if that's not an Allen charge, the Moore instruction is different than an Allen charge? Or is it just called the Moore instruction in California? Because remember how Massachusetts had the Rodriguez Toohey charge or whatever? It was the same thing, but it was just called different. See, that sounds like an Allen charge to me. But I'm a nurse, not a lawyer, so I don't know.
All over again. Now, the court may feel that it was out of consideration of the defense, which submitted an instruction that it relied on in closing, that it ought to, in fairness, extend to the defense the chance to explain or deal with the fact that the special instruction is not there. But we don't see any way that this case could be re-argued without the prosecution saying, my God, ladies and gentlemen of the jury, let me explain the tremendous importance of what the judge did. He's thrown this case open to new theories. I'm now going to explain the new theories. You've got to start your deliberations all over again. You've got to abandon your positions because the court has given you a tremendous signal by the withdrawal of this. So we adamantly oppose the reopening of argument in this case.
Well, good point, Wiggles. Somebody has to do it first. You do have a good point.
All right. I just want to point, and I'll hear from the people momentarily, that by doing that, based on all the cases I've read where this has been presented to the defense, it's not the first case where there's been an opportunity or an offer to re-argue. By not accepting it, you basically waive that issue.
Yeah, Your Honor, and let me be expected the court to raise this question. And the court would agree that it should not be withdrawn. But we have very explicitly and on this record stated that the court has offered an opportunity to the parties to re-argue the case in the absence of the instruction. We appreciate that. We feel that it would compound, it either would have compounded an error if an error has been committed. If an error hasn't been committed, it lays open the possibility of one now being committed. And on that basis, yes, we state on the record we are declining the opportunity the court extended to us.
All right. Thank you. People?
The only thing I would clarify is I never said, contrary to Mr. Reardon's statements, I never said that we regretted the tactical decision we made. We made the tactical decision to go with a charge to the jury of second-degree murder, and that's a tactical decision that we stuck with. The whole reason that we argued this morning under Lee is because the court specifically invited us to submit arguments on Lee. We read Lee in a way, and I think the court stated it this morning, that it's somewhat ambiguous and could go either way. We read it one way. The court ultimately decided it went another way. We did not, nor have we ever regretted any decision we have made tactically in this case. If Mr. Reardon's position is that he is waiving, on the behalf of the defense team is waiving any argument on appeal on this issue and wishes not to re-argue, the people submitted. That's fine. I'm assuming that takes into consideration the fact that it sounds like there's 2 or 3 things that are going to be done. The court's going to re-instruct based on the question and proposition thing that we went through. The court.
And I believe him. AJ regrets nothing every single thing he plans out. Everything. He said in interviews after the Karen Reed trial, all of her interviews that she did, everything was planned meticulously. So all this time that we're screaming and yelling, Karen, why are you talking to the press? Why are you doing all these interviews? You're crazy. Why are you doing this to yourself? You're going to sink yourself. It was all planned. Everything she said went through Jackson. He knew every single thing she was going to say, how it was going to come across. This man plans meticulously. He has no regrets. So when he says he has no regrets, believe it. He has no regrets.
Indicated earlier that it was leaning toward, and I'm assuming
We haven't decided that yet.
Okay, on more. That's
Right.
something that we still need to litigate, and
Right.
that would have some impact in our decision and our argument. But insofar as the withdrawal of special instruction number 3, that is a hiccup, if you will, for several of the jurors. As the court has stated on the record, it is not an accurate statement of the law. With the withdrawal of that, we're fine.
Okay. The parties may wish to give me some proposed language they want me to use to the jury in the withdrawal of 3, or I can just do it on my own. If you want to get together and perhaps work on something. Okay. Is there anything else we need to discuss?
Your Honor,
What's going to be the determination on whether or not you get more and in what form?
Let me give it some thought. I want to reread it. I'll do it right here, and then I want to think of it in light of whether it's necessary with, if we take the other remedial paths that we possibly can, whether it's necessary at this point. I might withhold more until, if there's further disagreement, I'll have to wait and see.
We do have some specific objections to the instruction that's proposed.
Well, here's what I'm suggest. Given the fact that the jury indicated certain concerns that I can remedy without resorting to the so-called more instruction, and the fact that it may be necessary later on to go to that instruction, or that's a possibility, I don't think I need to go there at this point. I think the better thing to do is take it in steps, see if what we're doing at this point assists the jury, and then if it doesn't, worry about it when we get there.
The only, I don't want to argue with the court. Okay. I would simply pose, I think, more answers some of the questions on the, I don't know what to call this, the jury questions, if you will. More specifically answer several of those questions. Now, there were several jurors who had a problem with special instruction number 3. The court is going to specifically address with more insofar as how the deliberative process is to be undertaken. That dealing with reasonable doubt. That dealing with whether or not everybody has to agree on certain things. That dealing with whether one person's opinion or one person's view of the facts is in opposite of others, and where that leaves them. More answers all of those questions, and it's not prejudicial to the defense in the least.
All right, let me say this. I think what I need to do is, why don't you tell me what your objections are? I'll give it some thought, and we'll come in earlier tomorrow, and I'll let you know.
Okay. Should I do it right now?
Yes, please.
All right. Your Honor, in the second full paragraph, beginning, it has been my experience. That first sentence we would object to wit, it has been my experience on more than one occasion that a jury which initially reported it was unable to reach a verdict was ultimately able to arrive at verdicts on one or more of the counts before it. First of all, that sounds like it's been particularized to this court and this case, which all of the other instructions are written in a broader, more neutral sense. More significantly, it sounds coercive that other juries are able to reach a verdict. If you guys were up to snuff, you'd be able to reach a verdict yourself. So we object to that. In the last portion of the last sentence of that same paragraph, of how long it takes to do so. We want you to, reach a verdict regardless of how long it takes to do so. I think that's a direct violation of Gaynor. Basically, you're telling them you'll be here until the bricks fall down, which with this building may not be that long, but
That takes nothing. A bad sneeze might bring this place down.
but that threatens them with being here for as long as it takes. Included that type of instruction. Going down the page, the second full paragraph from the bottom that starts as I previously instructed you.
Yes.
The first sentence says they can deliberate in any way they want, and then the court tells them how to deliberate, and then says, well, you don't really have to pay attention. I mean, to tell the jury, may I suggest that since you've not been able to arrive at a verdict, you do these other role-playing, game-playing, touchy-feely 21st century concepts.
This is Southern California, Mr.
It's I just have never been able to get there. But what it does is it says, we don't care. You can deliberate any way you want to, but here's how I suggest you do it. Besides being logically inconsistent, it is impermissible to tell the jury how to go about its deliberations. And new age or not, I just think it's inappropriate.
You mean you want us to take the hot tub out of the jury room?
No, you can leave the hot tub, just even send in towels.
Leave the bongs, but take the hot tub. And then that goes on to first sentence. That concept continues on to the second page.
Okay.
And that's it. Those are my objections.
Okay. Thank you. I'll hear from the people.
Your Honor, with regard to the, I don't know what your experience is, quite frankly, but I'll bet you this isn't the first time that you've had to send a jury back after they've indicated that they've had an impasse.
Very few, actually. Very few.
That says a lot about the trials you preside over. I'm not married to that particular language. I mean, that is whatever the court wants to do with that language. And with regard to regardless of how long it takes to do so, we can strike that, and it doesn't change anything one way or the other.
Well, in light of that, let me just take these things out.
Okay. With regard to the third objection, beginning with the sentence, I suggest would a court's suggestion, and I think it's an appropriate one. The court is in a unique position to help guide and give guidance to jurors as they deliberate. The previous sentence indicates you can take it or leave it. I'm just making a suggestion, and you may consider changing the methods that you've been following. The jurors may not know that they're entitled to change the methods that they've been following. I mean, there are cases that indicate that the jurors can and have changed for persons, changed the way they have deliberated, changed sides that they've taken. There are any number of ways that they can conduct their deliberations, and it's completely up to them. This is simply the court informing them that it is up to them and making some suggestions that may or may not be helpful. I don't think that's in any way prejudicial, and I'll submit on the rest.
What I'm going to do, thank you both. I'm going to start with the second full paragraph from the bottom. I'll take out the language. May I suggest that since you have not been able to arrive at a verdict using the methods that you have chosen, because that may be deemed a criticism, which I agree might not be appropriate, I'll simply indicate to them you may wish to consider changing the methods you've been following at least temporarily and try new methods, and then just give them the different things they can consider, which is merely, you might want to try it. Maybe you don't.
We're fine with that.
Okay. Anything?
No, Your Honor, but what we will do is if we do have suggested language vis-a-vis the withdrawal of number 3. And
right, I'd like to see it, quite frankly.
We will, if it's agreeable to you, fax it to you by 9 o'clock in the morning.
That's fine.
All right, thank you.
And why don't you come in at 9:30 tomorrow? The jury's coming at 10. That'll give us time to discuss anything that we need to do.
Good.
Okay? Thank you.
I wonder, too, could we, for some reason, I know that Mr. Jackson, when we
got to the final packet, the final redacted, modified change back in the jury instructions, he did give us one, but for some reason, no one on the defense team has it. I wonder if we could get an extra copy. I don't know if the government...
We'll make that.
Okay.
Okay.
All right.
And,
Good tomorrow morning meeting.
Yes, okay.
and we also would like to get a copy of the note from the jury if possible. For our records.
Oh, you mean this one here? Sure. Well, actually, here it is. The jury has reached an impasse?
Yes.
Okay.
Court TV, what are you doing? It did not notice. Stupid black screen, what are you doing? It's weird because it's black on StreamYard, but it's white on computer. Work. Okay, we are now on day 4. Oh, yay. Hurts, guys. Oh, we got a picture of the phone again. This cameraman's funny. Keen, I'll take a picture of the phone. The soft sit phone that is there on special appearance for Reardon.
All right. Back on the record, the defendant is present with his counsel. The district attorneys are present. The jurors are not.
You know that Will Smith song? Getting jiggy with it? We're getting glitchy with it. Getting glitchy with it. Na 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 na. Getting glitchy with it. Okay, StreamYard.
Met informally this morning in chambers to discuss finalizing the instructions, and I went over with counsel some of the problems I saw after considering some of the discussions yesterday. So where are we at this point?
I think it's probably did Calcrim 520, and I believe what you'll hear is an objection by the defense to the reading of any portion of 875. I'll let Mr. Rosen or Mr. Brown speak to that.
Well, I think that Mr. Reardon is going to handle it.
Mr. Reardon? Mr. Reardon?
Your Honor?
Yes.
All right. The point where right now we are proposing, and Mr. Reardon will argue this, that no instruction based on 875 be given, because it's going to invite Ireland error. We can't think of a way to avoid it. Mr. Reardon will more fully articulate that. We have proposed an instruction that I think addresses the concerns the court has expressed, and Mr. Reardon is going to tell us more about that.
Go ahead, Mr. Reardon.
Thank you, Your Honor. Your Honor, in chambers, we discussed various matters. We renewed our instruction number. We objected to any supplemental instruction on murder or implied malice murder, because that would only be appropriate if 3 was withdrawn. The court indicated that since it was going to withdraw 3, it would give a supplemental instruction on murder. And the court expressed the concern that unless it gave some instruction to the jury, they might be completely untethered as to what acts they might consider as the basis for implied malice murder. Under Special 3, they were limited to the act of having the gun enter the mouth of Miss Clarkson with Mr. Spector's hand on it. If the court is withdrawing that, would be those of the defense as well, that the jury might simply focus on something like brandishing, which might be the appropriate basis for a misdemeanor manslaughter charge, but would not be appropriate for a charge of implied malice murder. So it felt that the jury needed some direction and limitation, and it felt that the limitation ought to come in the form of informing them that the act that they can consider, the actus reus, has to at least have the gravity of a assault with a deadly weapon, which of course is a serious felony. And so where we left it was that we were going to look at some way to integrate that limitation to assault with a deadly weapon into a supplemental instruction on implied malice murder. And with, of course, having observed our objection instruction, we think that the solution is an extremely simple. And on the other hand, anything but a very simple one poses a great danger. So what we have proposed, the court take the implied malice murder instruction that it has already given, and hopefully the court has a written version of this in front of it, and simply say where it would normally say the defendant committed an act that caused the death of Lana Clarkson, the defendant committed an act with a deadly weapon that directly caused the death of Lana Clarkson. And again, when we get down to implied malice, number 1 under that, the defendant intentionally committed an act with a deadly weapon that directly caused the death of Lana Clarkson. And so the court then has given the prosecution the benefit that it has ruled that it felt it unfairly took away from it by specifying a single act, the act of the gun entering the mouth with Mr. Spector's hand on it. The court is saying that if the jury finds another act with the gravity of assault with a deadly weapon that caused the death of Lana Clarkson, they can rest a conviction on it. We have already preserved our objection that we don't believe that the evidence supports any other act other than the one now before the jury. It's a very simple change. It just gets relevant to the instructions and does add the word directly. And the reason for that is that there are no proximate cause theories.
Stupid StreamYard. I was going to comment on what he was saying, and then StreamYard muted me, and now I don't remember what I was going to say. Oh, brandishing the gun is brandishing the gun. It doesn't matter. Well, I don't know about legally, but to me, it doesn't matter. If you brandish a gun and then that person that you're brandishing the gun at gets shot, whether it's in the mouth, in the head, in the foot, it doesn't matter. If you were brandishing that gun and that person got shot, you're responsible. No. That's phone Reardon. He's there by special appearance. That's not Reardon. That's phone Reardon. He's a living phone on the land, there by special appearance. Bravo!
Direct causation case and not approximate causation case. And the one thing that we feel very strongly about is that if the court lift any more language from the ADW instruction, the assault with a deadly weapon instruction, and if it were to lift any language that talks about great bodily injury, which of course is the normal ADW instruction, that is that one does something with a gun that could reasonably cause great bodily injury to a victim, then the court, that term great bodily injury in any form would walk right into the Supreme Court's decision only 3 months ago in the Nolan case, in which a appellate court had written an opinion that injected bodily injury into the formulation in California, and the California Supreme Court reversed the First District Court of Appeals 7-0, saying that the great bodily injury language has no place in an implied malice murder case. So with having preserved our objections, we propose some simple additions to 520 that would expand the scope for the prosecution in the way that the court felt that to the extent that the court felt they should have.
This is when we have tech issues, right after we switch videos. I wish I knew how to download videos from here. AJ on her channel, which I don't remember the name of her channel. Her name is AJ. What is the name of her? The Alternate Juror. That's right. She did Betty Broderick's trial. So I'm going to have to get with her and find out what source she used, because I'm over these tech glitches. This is just too much. In fact, I'm going to turn my camera off, because I want to get done with this today. We're almost done. We are so close to being done. Oh, can you guys hear me? Just double checking, because StreamYard keeps muting me. Okay, I guess you can. You're not saying you can't hear me.
I guess I would ask for guidance from the court. Do I need to get to the amended 520 that Mr. Reardon just talked talked about, or is the court's intention to include the language of 875 as we talked about informally in chambers?
I'm looking for options here, so I think you need to address it.
Okay. The only problem, I wouldn't have any, and I don't think Mr. Dixon would have any problem with the amendment to the malice aforethought. The word directly puts us right back. I think more appropriately, I think it could be tailored a little bit more finely. The defendant committed an act with a firearm that caused the death of Lana Clarkson. The word directly in both paragraph 1 and the subsequent paragraph 1 under implied malice imposes a burden on the prosecution that simply doesn't exist. We don't have to prove, and the jurors don't have to find, that Mr. Spector directly caused, quote unquote, directly caused the death of Lana Clarkson. We just have to prove that he committed an act, that being assault with a deadly weapon or assault with a firearm, that ultimately resulted in her death so badly. Wants the word directly in there because it puts us back.
All right, Court TV. We got a couple hours and we'll be done with this puppy.
Was assaulting her with a firearm, and a struggle ensued, and the gun ended up in her mouth and went off. Any of those options, which are available to the jury factually, and it's up to them to make a determination factually what happened, would confuse them if the word directly is here. I can see a juror certainly saying, well, that's not directly caused. He would have to have pulled the trigger himself intentionally for it to be a direct causation. That one word simply doesn't need to be there, and that's not the law. It imposes a higher burden than is necessary. So if the court is considering the amended CalCrim 520, I actually appreciate Mr. Reardon's addition of the specifics of this case. I think it does do, it is in line with the facts of the case. If we amend it to say the defendant committed an act with a deadly weapon or with a firearm more appropriately that caused the death of Lana Clarkson. Paragraph, he intentionally committed an act with a firearm that caused the death of Lana Clarkson. We have no problems with that whatsoever.
Are you saying
the intentionally committed an act? I mean, that's
what's required.
Correct. That's
okay.
I'm not objecting to that at all.
Perhaps
I'm objecting to the word directly.
I misheard you then. Okay.
No.
Your Honor, I would agree with Mr. Jackson, and I apologize for the oversight. I think firearm is correct in this case as opposed to deadly weapon. So we'd agree to that amendment. And all I can say on the other is that there's two kinds of causation in the law, direct causation and proximate causation. If the word direct is not in there, it would leave the jury open to a proximate cause theory on which it hasn't been instructed. The proximate cause instructions were struck, and certainly the proximate cause instructions can't be injected into the deliberations at this point. So we'll submit it, but we would stand by the word direct.
All right. Thank you, Mr. Reardon.
Your Honor,
yes, Mr. Bruno.
Point, if I may. None of the three scenarios posited by Mr. Jackson would be excluded by the inclusion of the word directly. Each of those acts would be in response to the direct act and would be part of the direct act Mr. Speck had that. I don't think that this limit people the way the court.
Thank you. Mr. Jackson. I think it absolutely does. I don't need to restate it. I think it absolutely does. Those three scenarios, a juror could go back and say, well, that's not directly. I mean, if she slapped the gun, the slap directly caused the death of Lana Clarkson. I think the defense is playing loose with semantics, which are very important to the jurors. The jurors have shown how important it is to them with regard to special instruction number 3, which is now going to be withdrawn.
Without ruling one way or the other at this point, I'm going to have to give it some thought. We know that they're confused by it. We know that there's a problem, and the problem, I'm going to when we're done talking here, I'm going to restate exactly what's brought us to this. I'm going to summarize everything because I think it's becoming extremely confusing, not so much to the lawyers, we and myself, we know to make so dense that the general public doesn't know what we're doing, and it's very important to me that they understand why we're here and what we're doing, and I'll summarize it and try to explain the problems. We don't know what the problem with Special Instruction 3 was. We know that the jurors were confused by it, which doesn't mean that's why it's being taken out. It's being taken out because the language that was employed unduly limited the possibilities that the jury could consider, because the language that was used was this particular act, which was placing the gun in the mouth of Lana Clarkson in the hand of Mr. Spector. That is unduly murder is. It was given because that was the only theory that the people posited during the trial, but the jury is not limited just to that theory as long as they limit themselves to reasonable inferences that can be drawn from the evidence and do not speculate. That's what we, at the time of confusion, it then gave us me a chance to reconsider it and realize that there was a problem with it. That may or may not solve their confusion. We don't know what their confusion is. We don't know whether all or some. We know that some individuals have indicated they have a problem with that, but we don't know how they have a problem with it. To speculate that specific language in 3 is what's causing the problem, we don't know. I want to take a look at the proximate cause instruction and see if I believe any impermissible language is being used if we don't include that in the revised 520. Thank you. I would have number 4 in the instruction, whether it's the amended or the original 520 we gave, where the last, that sentence is, he deliberately acted with conscious disregard for human life. There's your deliberate. And why does it have to be re-expressed as you have done in your proposed instruction?
I'm sorry, which part of the proposed instruction is the court questioning? Number 4?
No, number 4 is a correct statement of the law. He deliberately acted with conscious disregard for human life. That's clearly the correct statement. In light of that, and what the language that the people are complaining about in your proposed instruction, which is that I believe it's he intentionally committed an act. Directly.
As I understood it, Your Honor, they were simply objecting to the word directly.
Exactly, and I'm saying, in light of number 4, which uses the term with the correct term, deliberately, why is that any different? What is added by your term of directly?
This has always been a direct causation case.
Yes.
The people's theory was that has been that Mr. As evidenced in their animation, that he had the gun in his hand, and when it went off, I mean, we are. I don't think there's any question that the jury is going to assume that pulling a Special 3 and adding this means something. And it does. The court intended to expand the language beyond the very specific detailed language of Special 3, and I think the word directly ensures that theories that Mr. Spector made deprecating remarks to Miss Clarkson that led her to shoot herself. There's no evidence in the record for that. That would get into manslaughter and so forth. Directly, while the language is expanded, it's it's not just the details of Special 1. It continues to be limited to a firearm that directly caused the death. I think it maintains the court expressed a great concern, and we're grateful for it, that they not just go off on a brandishing theory. Well, brandishings aren't implied malice murders unless they directly result. They can be if they directly result in the death of someone and they're done with implied malice. So I think directly helps impose the limitations. The court wanted to expand and limit the instructions to the jury. Withdrawing 3 expands and directly limits.
Your Honor,
Yes,
to
Mr.
directly
Thank you.
answer the court's question. The language of deliberation or deliberately acted in 4 goes to the mental state and knowledge. The act that directly goes to the act that causes the death. That's the distinction.
I don't disagree, but then I think 20 in its original state, and all we're doing with 520 is taking the specific acts of this case, putting them in 520 so the jury doesn't stray into brandishing. I'll explain that at length later. But the bottom line is, if you look at number 1, the defendant committed an act. It doesn't say the defendant directly committed an act. It says the defendant committed an act. And if the concern is that they're going to stray, that's not my concern. That's the concern is that it be an act with a deadly weapon and not merely waving it around. I have to take out any possibility of brandishing. The parties originally, I'll go into that, originally all agreed that was not an issue in this case. And if we get into that issue, then it's going to cause the problems with giving manslaughter instructions, which can't be done at this case at this time. And that's where we're at.
The elegance of this simple instruction. It requires the jury to find that Mr. Spector's act directly caused the death. It eliminates waving the gun around and something happening. It has to be an intentional act done with conscious disregard that directly led to her death. That is what the law under these facts requires, and that's all that this instruction requires.
And actually, I would direct the court's attention to subparagraph 2 under implied malice. That's not what it requires. The law requires that the natural consequences of the act were dangerous to human life and ultimately led to the death. It's directly in opposite of directly caused consequences of which.
I see another problem with this instruction. And my problem is it doesn't address the court's concerns that if we don't get very specific, that the jury might consider what is an act of brandishing and decide this case. And a brandishing can be a theory for second-degree murder, but the problem is it can also be a theory for manslaughter, and the jury has to be given the choice. Even with this language that has been proposed by the defense, it doesn't, as I see it, rule out the possibility of brandishing. That's why I said that the elements of an assault with the firearm have to be given because that's the completed act. That rules out brandishing because it goes beyond. The way you've written this instruction, it doesn't. It doesn't. It leaves the possibility of it. It's too broad.
Well, Your Honor, the problem is that if you deadly weapon, a statement that would result in bodily injury. Great bodily injury after Knoller is just absolutely verboten in an implied malice instruction, Your Honor. And what we have to do is ensure that the jury knows that it's got to be implied malice, conscious disregard of life, which is completely inconsistent with the elements of assault with a deadly weapon. The cite to that is 3 or 4 months ago, 41 Cal 4th,
All right. I'm going to need to take a look at that case.
And it was a case in which
I'm very familiar.
the Court of Appeals viewing the murder
Mr. Reardon.
granted a trial and said that a conscious disregard about a would support an implied malice conviction, and it was reversed 7-0 by the Supreme Court.
Thank you. All right, let me. I'm going to go read it. Where's your off button, Mr. Reardon? Thank you. I'm going to go take a look at the case. I want to look at the specific language that you're concerned with and see how it applies to the fact situation we have. So I'm going to take a short recess and we'll get back. Thank you. Oh, yes. But you have to set the phone so it only gives very short replies.
He's been spoken to.
You can't hear on the speakers.
I know.
Speakers on.
He's on?
He's calling.
Oh, okay. Okay. Mr. Reardon? Mr. Reardon?
Maybe you asked for too much.
Mr. Reardon?
Yes.
There. Can you hear me, Mr. Reardon?
I can, Your Honor. I've got my finger on the off button.
All right, thank you. All right, I have taken a look at the Knoller case, and it is instructive, and it does have some bearing on what we end up doing. That's Knoller, K-N-O-L-L-E-R. Okay. And I agree, Mr. Reardon, with the defense contention that if I were to instruct with the language of ADW, that would be a problem because the language that is in the instruction or pointed out in filing a conviction on an ADW without the language that it would lead, knowing the risk of death, I'm paraphrasing, is impermissible. And that's what the court said. However, your instruction still does not answer my concerns, and that's where, and let me try to summarize what the concern is. This case was presented to the jury, presented to the court on a very specific theory, and that theory was that Mr. Spector either basically placed a gun in Miss Clarkson's mouth, causing her death. The people are correct in pointing out that although that is their theory, that as long as the jury relies on evidence that was presented and the instructions that the court gives it, they're not bound by that theory as long as it's instructions. One of the problems is that from the facts presented is that the jury, because this is a murder case, was presented only on the theory of murder and not on the theory of manslaughter, which both sides were adamant that manslaughter did not apply to the facts as presented, because if indeed Mr. Spector placed the gun in Ms. Clarkson's mouth, that goes beyond the crime of brandishing, which is a misdemeanor. Brandishing, however, can serve as a basis for both manslaughter and murder. It depends on whether the jury finds that there is a implied malice theory, and if they don't find the implied malice, they can convict on manslaughter. If they find the implied malice under the same set of facts, they can convict of a murder. The jury has not been instructed on manslaughter because of the fact that both sides agreed that under the facts presented there really wasn't a brandishing, that if anything, there was a completed act with the firearm, whether we call it an assault with the firearm, but it went beyond merely brandishing, which is exhibiting, and again I'll paraphrase, exhibiting a gun in a rude, threatening manner. That's one possibility for brandishing. Because of the timing of this case, if we went back, and one of the things the court had considered, and I considered it because I thought the Lee case that I cited might make it mandatory in all cases, even where it goes beyond a brandishing, that it still be given as an option to the jury as a lesser related offense. It is not an included offense, it's a lesser related offense. I think Lee can be distinguished. We talked about it yesterday, although it was a concern of the court originally. I think Lee is limited to its facts. Under the facts of that case, there was only a brandishing led to the death, even though there was a contact one. So I'm not concerned that Lee is the controlling factor. But one thing we have to be sure of, I have to be sure of, and the law has to be sure of, is that because brandishing, if you give brandishing, if the jury is considering, it would have to be instructed on manslaughter. We can't instruct them on manslaughter under the Stoddard case and the Jennings case because of the time we now realize the jury has indicated a problem. By doing so would tend to direct that they find a manslaughter. That's the reason I'm not going to do that, and I stated that yesterday. I have to be sure, and this problem sort of became apparent when Mr. Jackson was talking about the theories that the jury could consider, and while I'm in total agreement, and the reason that we're withdrawing instruction number 3 is although the jury may consider certain acts other than directly placing the gun in her mouth, and we've posited some of the possibilities, they cannot consider the act of brandishing. If they do that, they're going on an improper theory under the way this case must be instructed. And I have to be certain by the instructions they're given. And when we had instruction number 3, that wasn't a concern because it specifically stated you must, which had nothing to do with brandishing and went way beyond that. I have to be satisfied that before we state the instruction, whether we modify 520 or whatever, that the jury needs to know, cannot consider the mere act of using the gun or something like that. In other words, if they start to think and get together, oh, Mr. Spector was waving the gun and somehow the gun went off and that killed Ms. Clarkson, that would be possibly murder, but it also would be possibly manslaughter. So we have to take away that consideration. This instruction as drafted by Mr. Reardon doesn't do that.
Well, Your Honor, why don't you just include that language that you just stated in this instruction? I further instruct you that the mere act of displaying or waving the gun around would not be the basis for a finding of implied malice.
I thought of that, and that's one thing I want to broach to you at this time, whether that we can incorporate that, but they also have to understand what can be used. I mean, that's fine, but they have to understand without using the specific language from assault with a deadly weapon, because it has that fatal flaw, if you will, in the language that gets it out of implied malice. We have to find a way of stating, and it may be very specific acts. If you find A, B, and C, that's acceptable, but if you merely find D, E, or F, that is not. This is the problem I'm facing, because otherwise we're not going to go, this case basically can't go forward with the way the instructions are written now. So you may want to spend, we're already at 11:45 in lunch hour, try to do it as well, but I think we need to try to address appropriate language that addresses my concerns, that allows the case to go forward on the appropriate theories, that the people are not cut off from correct theories that the jury can consider, not limited to the one that the people posited in instruction number 3, but at the same time the jury doesn't go beyond what they may. That's what we have to do.
You know, Judy, like you said, yeah, it does kind of make me anxious too, but at the same time, there's an open line of communication between the jury and the judge. And that was the problem in the Karen Reed trial. And yeah, we know she was biased and she wanted her to be convicted and everything, yeah. But still, I think it's good that there is an open line of communication between the judge and the jury, because you can't, so many judges, they ask a question for clarity and the judge is like, oh, I can't answer that question. Well, why not? you're supposed to be the person that teaches us the law. We're not lawyers. We don't know the law. We're trying to decide a legal question. You know the law, and you keep telling us you're going to instruct us on the law. Why can't you answer that question? So I like this, that there's an open dialogue, and I think it should be done more often when a jury had. Now, yeah, if they want to read back a portion of the transcript or see a demonstrative or something that's not allowed in that state, then that I get. But at least some type of rationale for why they're saying I can't answer that or answer it, you know? Don't just say, oh, you have all the information you need. That ticks me off. If I ask somebody a question and they told me, well, actually, that has happened in nursing school. Because that's critical thinking, and you're supposed to be able to do that if you're a nurse. But the thought of you might possibly have someone's freedom in your hands, and then you ask a question to help you decide, and the judge is just like, oh, you have all the information you need. I can't answer that. That would kind of tick me off a little bit, which is why I'm glad I don't ever have to serve on a jury anymore. Although it would be extremely interesting. I'm exempt for chronic illness reasons, but yeah, I would have such a hard time. I mean, not in cases like the Jim McIntyre case, which I'm going to start calling it.
So put your heads together, see what you come up with. I'm going to work on it over the noon hour, and we will resume at 1:30 this afternoon.
Could we let the jury know, sir, how this is going? So,
well, obviously, we'll send. Yeah, so they're fine. Okay. All right, we're in recess till 1:30. Cal 4th, 1083 at page 1145. And go down to head note 27. The acts they found, and if we can use that language somehow, that may prove useful. 20 at page 1145. That's the page, and that's important. All right. 28 Cal 4th, 1083 at page 1145. Okay.
Thank you.
Thank you.
Order, court's in session.
No, I've read it, I'm familiar with it, and actually don't need it. There's problems with it that I'd be happy to express to you. All right, take a moment, take a look at it. All right, the parties are present as heretofore. Jurors and alternates are not present. Mr. Reardon is also present by speakerphone. The parties are looking at a proposed instruction that was submitted by Mr. Reardon. I have some very specific problems with it, and the parties are free to look at it and comment as they wish.
Is that one that the court drafted, or did the defense, looking at the title, court supplemental instruction, I'm assuming that's just a title? Okay.
And I have taken the liberty of drafting, which I will have to read because I only have a copy. I believe now proposed instruction should read, and then I sort of move along after we discuss it so we can get to the jury.
Okay, there's something that I would like to bring up, and I think we'd like to address with the court. All of this kind of hit us relatively quickly with the court's conference call last night with Mr. Rosen and myself. And then the
I
discussion.
should state, we had, in anticipation of some of the difficulties we've been discussing, I did have a conference call last night with Mr. Rosen and Mr. Jackson. Mr. Dixon got cut off in the middle of it, simply to give the parties a heads up that I had some concerns about the instructions that we've dealt with today or dealing with, and that was the content of the phone call.
Over the lunch hour, we all got together, had a chance to kind of take a deep breath and take a look at what it is that the court expressed some concern about. And the court synthesized its concerns, both in chambers and out on the record, as basically as follows. It feels as though we're to allow the jurors to continue to deliberate based on an act. Let's just call it an act, whatever act that is, and the court indicated, with gun around, et cetera, or any act between that and actual assault, a deadly weapon assault, that the court would be compelled to give the lesser charge of involuntary manslaughter. And the reason the court gave is because the court indicated that with that particular act, that could also constitute an involuntary manslaughter, and if that included offenses obligations. And given the fact that the court doesn't feel that it can give the lesser included offense because of Jennings and its progeny, it's in a bind. We have been looking at this in absolutely, I think all of us have been looking at this in absolutely the wrong way. Okay. It dawned on us, and literally, well, not literally, figuratively as it can get, a light bulb went off as we sat and discussed this. And I looked at a case called Benitez, and
I am very familiar with Benitez.
Okay, and I don't think any of us are in disagreement about what Benitez says. And the court has made this sort of finding, if you will, acknowledged the finding of Benitez several times that, for instance, a brandishing can be, a 417 can be the basis for a second-degree murder. But it has to be brandishing plus something. And something is an extremely simple resolution. I think the court's concerns are covered by the recognition that we instruct and continue to instruct and maybe re-instruct on the necessity for the jurors to find malice. Brandishing alone, or any waving or an act like that alone, will not support a conviction for second-degree murder unless it's accompanied by malice. Since the jurors have been instructed and will continue to be instructed on the necessity to find malice, any act that they determine is accompanied by malice will legally support the second-degree murder conviction. Now, the court indicated, what if Mr. Jackson, we were talking back in chambers, what if Mr. Jackson, they decided that they wanted to use a 417 as the basis for their opinions, one of them or six of them or all of them, and they don't have an involuntary manslaughter to fall back on, which is what the court was understandably concerned with. The answer is very simple. Is not accompanied by malice. If the court had given the involuntary instruction, the fallback would be involuntary manslaughter. Without the instruction, the fallback is not guilty. The defense had an opportunity to ask for the subordinate crime, the lesser included offense of involuntary manslaughter. We had an opportunity. We all decided amongst ourselves, strategically and tactically, that was not the direction we were going to go. So now the choices are simple. They have to find that an act was committed, and they have to find that that act is accompanied by malice. If they find that the act was committed and it's not accompanied by malice, then the defendant gets the advantage of a not guilty verdict from that particular juror, and if all of them agree, from that entire jury panel. I don't think the court has any concern, there shouldn't be any concern on the court's part that it isn't instructing on involuntary manslaughter, because that's what the consequence is. a not guilty verdict instead of a lesser included offense. Does that make sense?
Well, I understand exactly what you're saying, but it doesn't solve the problem.
How so?
It doesn't solve the problem because it follows. In the very case you cite, you realize that the court gave both manslaughter and murder instructions because
Absolutely.
the court is required to give instructions on anything that is within the evidence presented. It's not limited to the theories, and that's why we spent so much time originally talking about what the possibilities were, whether there was any possibility to base a manslaughter conviction on, and then, and I mentioned at the time, and I have mentioned several times, and all the parties recognize it, that even if you both came to me at the conclusion of evidence, and if there had been evidence that would support a manslaughter charge, and you said, we need to get tactically from both, we don't want it. The defense says to me, we don't want it. We accept that, you know, if we don't, you don't give it and there's a conviction, we can't go to the Court of Appeal or the Supreme Court later and say, judge made a mistake because the evidence supported it, because in essence we've waived it by making
I didn't know that
a tactical decision, so-called invited error. And you had said we don't want it for tactical reasons. We like all or nothing as well. We just, you know, manslaughter to us for whatever reason.
I didn't know that the judge had to give instructions regardless of the theories. Like, they have to give all the instructions for, what did he say, manslaughter? Regardless of what theories gets presented at trial. If the evidence is there that it could be something else other than what the theories are, he still has to give the instructions for it. I didn't know that. That would be scary to me as a prosecutor. Because what if somebody on the jury thought all of my theories were wrong, and I don't know, that would be reasonable doubt. I don't think that's a flaw, Judy. I think sometimes it's a good thing.
Not acceptable. That doesn't control what I do. The sole reason I did not give manslaughter instructions in this case originally was because we did not have a theory. I specifically asked, is there any theory upon which a manslaughter conviction can rest? I said, I can't think of one because we did not see a brandishing. And the reason we did not see a brandishing was that everyone was in agreement that whatever happened in this case, it was a completed assault. It had to go beyond brandishing, which took brandishing away from the jury, it took it away from any possible consideration. What you are asking me to do at this time is to say,
actually goes into a literal assault, then brandishing it goes away? That doesn't make sense. Because if you rob a store and you shoot the clerk, you get charged with robbery and shooting. They don't take the robbery off just because you shot the clerk. That might not be a good example, but I'm not a lawyer, so I don't know. But I think that's stupid.
Manslaughter conviction can rest. There's beyond a brandishing. There is no brandishing, but it's something that does support a murder conviction, which is true. We all agree that if you have a mere brandishing, it can support a manslaughter. It can also support a second-degree implied malice murder conviction. It depends on whether the jury finds malice is present or malice is absent. My concern, and what your argument does not address, is if that jury goes in without proper instruction, and for instance, on an act just says, well, you know, he waved the gun around, we think that's dangerous, that's great. Well, all of a sudden, there's a theory that supports manslaughter instructions, which I can't give at this point, if that's what you thought, because of the timing in the case. I agree with you that brandishing, if it's there, can support the murder charge. The problem is, you're telling me, and you have told me consistently, both sides have told me consistently, and I have agreed with you, there is no brandishing because it's gone beyond it in this case. And my concern is to let the jury consider something that isn't there.
I understand, and I guess what I'm trying to point the court to
And I realize when you say, well, if they come back with a murder conviction, by necessity they found malice. That's fine when they also have a manslaughter conviction because they tell it. It's fine because if they do so, it's clear that they found malice, but you've also told me that that theory doesn't apply, that there is no brandishing.
Except there is, I mean, that's up to the jurors to figure out. We obviously had a theory that we were proffering and that we continue to proffer. It's up for the jurors, or up to the jurors, to make a determination as to which facts fit which law. If in fact, and this speaks directly to the court's concern that if in fact a juror goes back and says, well, I think he was waving a gun around, it was dangerous, et cetera, and you just said that supports a manslaughter conclusion.
It also supports a murder conclusion. Only
if there's malice.
I agree, but you keep telling me it's not there. The facts are not there. Not that it's not a theory you proffered. We have all agreed, all the parties, that there is not a brandishing in this case because it has gone beyond a brandishing. I understand perfectly your theory. You keep telling me on one hand it doesn't exist, and then say, but that theory does support it.
What I'm saying is to address the court's concern that if in fact a juror were to find that, and if in fact the juror says, hey, look, it's dangerous, what he was doing was dangerous, et cetera, you haven't instructed on a manslaughter, and that would be consistent with manslaughter. Okay, fine. So the alternative is not guilty. That would be their alternative. I mean, am I?
You're not obtuse, Mr. Jackson. I understand it, but you're asking me to ignore. And I know I don't mean this in a derogatory fashion. You're speaking out of both sides of your mouth. On one hand, you say the theory's not there. No juror could come to that conclusion. That's what you're telling me when you say, Judge, there's no basis for manslaughter. When we started out in this case, there's no basis for it. There's no brandishing. And now you're saying, but it's okay for the jurors to think there is, or to use that as a conclusion. You can't do that.
Our theory had been that this is what ended up, the completed crime ended up being a completed second-degree murder. That is clearly our theory. And I don't want the court to think that I'm intentionally speaking out of both sides.
No, and I want to make clear that when I use that term, I'm not being cute or anything else. I'm saying you're making two arguments, one which goes one way, one which goes the other, and they're not compatible.
I guess I'm saying what the compatibility is, we make certain determinations and tactical decisions based on the theory of liability that we think exists.
That's correct.
However, the jurors are entitled to draw from that same set of facts that we have synthesized as best we could. They are the triers of fact. If everything I said was absolute gospel, then I'd win all my cases, I suppose.
And that's correct, and that's why instruction number 3 is coming out, because it prevented the jury, although, and let me say it again, when number 3 was presented the first couple of times I turned it down, it was clearly a misstatement of law. Ultimately, you had one theory, and I realize the jury isn't bound by that theory. And your theory was that Mr. Spector put the gun in Ms. Clarkson's mouth, fired it, and that's how she died. And based upon that theory, the law was consistent with that theory. It was a pinpoint instruction that matched your theory and told the jury what it had to do. Now that the jury, and I think it's important to look at where we are, they have indicated we have a problem, and the jurors mentioned specifically, one or more, had a problem, unknown as to what the problem is with instruction 3. We know that somebody is having a problem.
Oh, for crying out loud. Why, Court TV, why?
Take advantage of that. There's no problem with that. That's perfectly legitimate. Although you never argued it, it's legitimate, and that's why 3 is coming out. It's too restrictive. It's unfair. The mere fact that it was confusing the jury doesn't mean it can come out. That pointed up a problem with that instruction.
Right.
I recognize, and I have told you all in chambers, that by taking away, if you will, an otherwise viable theory, if we had instructed on it, including the manslaughter instructions as to brandishing, yes, you're giving up something. But in my mind, with the argument you're making, you have two choices. You have to give up the brandishing argument because everyone keeps saying it's not there. If it is there, I have an absolute duty to instruct on it. Since I can instruct at this point, what the alternatives are.
And I guess I won't beat a dead horse. I just wanted to add a little food for thought, because this is a kind of a dynamic process as we all think about this. I guess what I'm suggesting is that the other alternative is not simply a motion for a granted motion for mistrial. The other alternative is the jurors get the instructions that they've already been instructed on. The court answers the questions that they've got, the ones that we went over yesterday. The court re-instructs them on 520 and what the malice requirements are. And if they don't meet it, whatever their theory of liability is, the alternative is a not guilty verdict. That is an option. That is the other alternative. It's simply stuck. If for instance, there was conviction in this case on appeal, some appellate court would say, well, they should have been given the instruction involuntary manslaughter, although the defense didn't ask for it for tactical purposes. Jurors might have considered.
In other words, he wants a compromise verdict.
Something less than a deadly weapon, for instance, waving around or whatever. And as appellate justice jurists, should they have come back with an involuntary manslaughter verdict? Well, the other alternative was simply not guilty. If the safety net, if you will, of the lesser included offense is not there, then they jump all the way down to not guilty. There is no safety net for any other conviction. It's guilt of second-degree murder or not guilty. And I guess that's what I'm trying to. I'm not as articulately putting it as I should, but
no, I understand what you're saying, but that's still error. And the bottom line is, yeah, if they acquit, then that's the end of the process. But if they convict of murder, and the reason I don't think your solution, which certainly I thought of, and I'm sure we all thought of it long ago, was, is it not unreasonable, given the facts presented, that they could go off on this brandishing? And normally that would be covered by the instructions, but we're in agreement that brandishing can't exist, and therefore they have to be told that. That's my position. Now, the instruction that was submitted by the defense, drafted by Mr. Reardon, is unacceptable to me for the following reasons. It did incorporate the language of brandishing, that would be insufficient. To me, it ends up being one-sided. It does not tell them what they can consider. That was, if you will, instruction number 3 originally took care of that, took care of the act by describing it, but now that's no longer there because it's too restrictive. So what I would bear with me, and there may be other possibilities, some of these possibilities may not be applicable. What I have done is I have taken 520, reasonably been shown by the evidence that might have occurred that would support a murder conviction. I have also incorporated the brandishing language so that the jury cannot consider that, because that would be inappropriate, and the instruction would read as follows. The defendant is charged with murder in violation of Penal Code Section 187. To prove that the defendant is guilty of this crime, the people must prove that, 1, the defendant committed an act with a deadly weapon, or we can use firearm or gun as the case may be, that caused the death of Lana Clarkson, such as, and placing the gun in her mouth, at which time it discharged.
To be honest, I'm not looking at his, so I haven't seen it.
Or by pointing the gun at or against her head, and it entered her mouth and discharged. Or by pointing the gun at her to prevent her from leaving his house, causing a struggle, which ended with the gun entering her mouth and discharging. Or forcing her to place the gun in her mouth and it discharged. If you find, and then if you find Mr. Spector used the gun, and the instruction would go on with the rest of the murder, the implied malice and malice. Any of those theories exceed the possibility of the evidence. Those are the ones that came to my mind. I am happy to include or exclude as necessary.
I think Mr. Reardon wants to speak first.
Mr. Reardon.
I think that, frankly, if our Special 3 was unacceptable because it limited in.
Stop.
There could be other acts. I think we've erred in the other direction because once you start listing specific scenarios, at a minimum, you are telling the jury that that those are at least reasonable, rational possibilities supported by the evidence. I think I think particularly as would be wrong. If the court were to take our understand the court's concern that while we've brandishing by using our paragraph there, the key words of course are in itself, or we could use alone to send the message that that the brandishing alone isn't enough. But of course, as we agree, those actions accompanied by malice of forethought and death would be enough. If there were general language which said that these kinds of acts, however, can be sufficient if they're accompanied by the following elements, then I think we're in the area of general legal principles. The kind of instruction the court is given, I think, is subject to the argument that's often made about Sears instructions or pinpoint. Left to the jury the nature of the evidence when that's a task that only they can do. So aside from our back to the listing of the hypotheticals, Your Honor, if we're then of objection, I don't see how that Mr. Spector forced Ms. Clarkson to put a gun in her mouth has any basis in the evidence, Your Honor.
We are finishing this today if it's the last thing I do.
The notion that he forced her to put the gun in her mouth, I just don't see anything but speculation that could support that, Your Honor.
All right.
I don't mean by saying that to suggest that I think the others are more acceptable. I think the examples are all problematical, and we would object to them on that ground.
Thank you. People?
Your Honor, actually, the way the court has fashioned the instruction, as it, with the exception of my first comments, if we're going to get pinpoint instruction,
Of a pinpoint instruction.
I think the four scenarios that the court penned, with regard to what the reasonable juror could glean from the evidence as it's been presented. With regard to Mr. Reardon's last comment concerning forcing the gun in her mouth, first of all, we know that the gun was ultimately discharged in her mouth. We know that there was or at least there is evidence that a reasonable jury could accept that there was a struggle, given the bruising on her wrists, given the fact that one doesn't normally place a gun in one's own mouth. I mean, obviously the defense posture is if she was committing suicide, she would, but that's completely different. If the court is directing the jurors the evidence available to them or the theories available to them to that which can be reasonably gleaned from the evidence, these four absolutely cover it, and we wouldn't have any objection to it.
Are there any others that you, and certainly Mr. Reardon has just indicated one that he has an objection to, but I feel it's within the realm of the evidence. Are there any others that you believe apply?
I'm quickly trying to think under the...
Well, don't strain yourself. I mean, and I will, however, Mr. Reardon made a suggestion that I will accept, and that is I will tell the jury I am not suggesting to them that these possibilities, they're not bound by it, nor are they limited by the language.
Before we get too far down.
Brad, just one second, and I'm sorry. I did just want to add one other comment, Your Honor.
Yes.
I'm not going to quarrel with the court's ruling, but I think we just do have to point out
StreamYard, quit adding crap. I just got a notice across the top of StreamYard that said Debbie entered the stage. Yeah, I know. I did it myself. I didn't need the announcement. That I need for it to run correctly. Stupid StreamYard.
It's been 84 years.
Well, when I say suggesting, I mean it's at least informing, telling the jury they can entertain are four scenarios, none of which were discussed in the prosecution's closing argument, and therefore none of it was addressed in the defense argument, and the court tells the jury that, of course, I realize.
See, what's happening right now is that Court TV is buffering.
Verdict along these alternative lines, and on that ground.
Comments after I played that. And now it's just going to totally crash again. I don't know why one depends on the other. It shouldn't. They should have nothing to do with each other. I don't know why it does that.
Federal constitutional grounds, we would object to it.
Well, I'm suggesting that these are mere possibilities that they may consider. So,
Here's
yes.
an additional problem, Your Honor. Your hypothesis number 3, that he pointed a gun to prevent Ms. Clarkson from leaving. Pointing a gun is the significant element. Ascribing a motive to it is simply re-arguing the prosecution's theory, and it implies that the court has put credence into that theory. And I think that that would be improperly argumentative, no matter what. But simply saying that that's a possibility says it's past the threshold.
Go back and change all the instructions. We're just looking at special instruction number 3.
Threshold of credibility with the court. And I think that is improper. In addition, it doesn't propose any of the defense's alternative explanations that she was depressed about her job, because of her depression, and simply experimenting with conditions which would potentially raise a doubt. So being concerned about our following the court's admonition to eliminate brandishing as a potential theory, this goes to the far alternative extreme, and it simply is re-arguing the prosecution's theories on variations of what Mr. Spector may have done to cause her death. And
The bottom line is this is contained in the instruction defining murder. It doesn't belong there. You have argued reasonable doubt, and reasonable doubt, you've given them a complete alternative suggestion as to these events that mandates that Mr. Spector be acquitted. If they have a reasonable doubt or believe, even if they don't believe, just excuse me, let me finish. If they don't believe necessarily and therefore I have a reasonable doubt if that's what the jurors believe, then they should and must acquit.
equivalent scenarios so that they can consider those, so that they have those before them as they have the prosecution scenarios.
Because I don't think there's any instruction theories under which they may convict of murder. I disagree with what you're saying. I don't think it fits in at all. You know, may I add, you've been given the opportunity. You have chosen for tactical reasons not to. If you want to re-argue this, and of course reasonable doubt is part of that to the jury, take the opportunity and do so.
But that's taking the dog by the tail and waving him. If that was going to be where we were going to end up, we should have started out heading there. You can't retry the case after it's been submitted to the jury, after we've all completed our theories and done our evidence and made our tactical decision. You can't do it after a week of deliberation and say, well, why don't we try it another way? You know, the problem we have here is caused by the tension between Lee and Stouter Jennings. something that they're concerned with. To instruct on lessers, but we can't because of where we are and what the state of the deliberations are.
Well, let me just say on instructing on lessers, at this point, that we still stand with the evidence doesn't show a brandishing. The evidence shows a completed act.
You're right, Jill. It's wagging the dog. I knew that sounded weird. I was like, what does he even mean by that? You're right. Tiger by the tail is when, like when you're over your head and something, right? I think. Isn't that what that one means? Like when you've taken on more than you can handle accidentally. I think that's having the tiger by the tail. But I don't remember what wagging the dog means. But I think you're right. I think you got the expression wrong.
I think that it would be appropriate to renew our motion for mistrial and not try to jury rig a solution that's going to come down to his detriment.
Well, first of all, once again, if I thought manslaughter was required as a matter of law, that would be the end of it. We would be there now. I am telling you that, first of all, take Lee out of the picture. I put Lee in, that I took a look at this case. I became concerned when I found it that it might apply to the facts of this case. It's holding to the degree that whether or not it applies to the facts of our case is somewhat ambiguous. I've become satisfied after reading Lee that it applies to the facts of those cases because the nature, I was concerned about the nature of the wound. There was a possible, the struggle that led to the death of the decedent in the dip. In this particular case, no one has ever suggested. The evidence is not suggested, and if you look at the People's 1101B evidence, which for a very specific purpose to show that Mr. Spector might have a motive, that he reacts in the same way, and the way he reacts based on the testimony, if the jurors find it to be credible, that's up to them, is each time he was placed in a similar situation, he actually placed a weapon to someone's head. That goes far beyond brandishing. That is the completed act. That is what the people are attempting to show happened in this case. There also are some alternatives to that which fall within those parameters which this instruction that I've drafted attempts to answer. If I believe that manslaughter had to be given, we would be done. There's nothing, your motion would have been granted. You know, the parties have consistently told me manslaughter doesn't apply.
Let me say, Your Honor, that we reiterate the position that you correctly instructed the jury. There was no evidence to support manslaughter in this case because the prosecution's theory was that Mr. Spector committed an act that certainly was one consistent with the implied malice, and the defense position was simply that he never committed that act. So I continue to believe that you correctly instructed the jury in the original instructions you gave him, Your Honor.
All right, thank you. All right. With that in mind, I'm going to go back to chambers, redraft this instruction. I just want to make sure that we're on the same page with regards to we're going to give special instruction regarding the jury's questions. Does somebody have them there, or do you want? I need to get them out of chambers. Does anybody have a copy?
The jurors, you know what? Let me just give you my copy.
Okay.
While you're doing that, alternative number 4 that the court gave?
Yes.
Can you read that again? I wanted to make sure.
Sure. It was or forcing her to place the gun in her mouth and it discharged. And that is within the possibility of the evidence.
So that implies that, well, when you say that, what evidence supports that?
It's simply a reasonable inference that whether we don't know how the gun got in her mouth.
Who's holding it, her, him?
Doesn't make any difference.
So either one?
Yes. Okay. All right. We'll be going over the jurors' questions. Whether the instruction should be taken by itself instead of taking all the instructions as a whole, I believe that will be answered by the more instruction, which is we're calling special instruction number 4.
Judge, we do need to address when you get to it the special instruction 6 that the government has added some language to it, which I want to comment on.
Special instruction. Yes. I haven't seen it.
I'll give it to you right now. Special 4 as well. I do. This is a book. Which copy with the history of the class?
Yes, what, Mr. Rosen, you wanted to address something?
Yes, if I could for a moment. Special Instruction 6, which we've already chatted about. The prosecution indicated earlier this morning that they were going to add some language, but it looks like in their final draft they've added more than what we talked about. I don't have a problem with the first sentence starting with "in your deliberations." The problem I have is treat it as if you never heard of it. It adds too much emphasis to it, and you are withdrawing it, and adequately state that in paragraphs 1, 2, and now the paragraph 3, but it should only be the one sentence. So we are asking that the court delete, treat it as if you never heard of it, that language.
I thought we had an agreement that we were going to give the instruction as drafted by the defense with one additional sentence.
Judge, the last sentence that I read to you in chambers is the following. In your deliberations from this point forward, do not consider the now withdrawn special instruction 3. Treat it as if you had never heard of it. That's exactly what I read to you.
As a matter of fact, we did discuss that,
and that's exactly what I wrote. I didn't add one
That
word
was to tell them to completely disregard it.
Right. I didn't add anything or subtract anything.
That's specifically, now that Mr. Jackson reminds me, that's specifically what we had agreed upon when we left chambers.
I don't know that we agreed upon it. My impression was that they were going to draft it, add the language to it, and we were going to take a look at it. And when I see it here in print, it is just those last few words that I think does overemphasize it too much. I mean, you are taking it out. It's being withdrawn. You look at the third paragraph, which should be the one sentence without the quote unquote treated as if you never heard of it, in conjunction with paragraphs 1 and paragraphs 2. I mean, it's about as clear and as strong as you can be. I think this just adds too much emphasis to it.
Okay, the objection is overruled. Okay. Okay, and we have special instruction 4. I just want to go over the, question number 1 is answered by special instruction 4. I want to make sure it is.
The ones with the hash marks through it, I think, are the ones that the court indicated we didn't need to address.
No, but I'm addressing number 1, and the question is whether the instruction be taken by itself. They were talking about number 3. It's no longer applicable. That's right, because 3 was actually out.
That's right.
It's out because it has been withdrawn. Question number 2, which dealt with instruction 3, is out. Question number 3 perhaps dealt with number 3. It's whether determining the weight of the evidence, the totality of the evidence should be considered, or the weight of one specific instruction.
I think your comment was at that time you were going to handle that in conjunction with number 1.
Okay. What I'm looking at there, because in the opening instruction, it tells them how to consider that, but I don't believe the more instruction addresses it. In the opening instruction, Calcrim 200, it is pay careful attention to all of these instructions and consider them together. Excuse me, that's not what I... Right. Pay careful attention to all of these instructions and consider them together. It tells them how to do it. You consider them. And I will simply reread that to them from Calcrim 200.
I think in the paper that you have in front of you, Judge, I indicated, or it should be, when it says Calcrim 200, it should say paragraph 2 and 6 or whatever. It should direct the court right to where it needs to go.
Question number 4.
Thank you.
And to consider everything in total. Question number 5, I want to reply that they cannot see the clothing because it's no longer in, number 1, it's not in evidence, and number 2, it's not in the condition it was, okay? Concepts of, number 6, questions of reasonable doubt. I'll reread the reasonable doubt instruction. You asked that I not respond to number 7, that it's appropriate for one juror to believe a fact is reasonable while another believes the fact to be unreasonable. Is that still the position, as opposed to saying that's basically, if one finds it to be unreasonable, that's their decision?
No, my position was it's covered in the more, if I didn't write it down there, our position is it's covered in the more instruction that each juror is, wherever that language is about each juror's independent.
Well, they're entitled to the individual judgment of each juror. Okay.
Yeah,
Are you satisfied that?
Yeah. I think the court's comment is apt, that a juror who holds an opinion that the juror feels is reasonable is entitled to hold it.
And that's the problem. They have to be told that. They're asking, and just because one has a differing view, that doesn't mean that they're unreasonable.
Absolutely.
Well, they have,
no problem with you explaining that.
They have to be told that.
Sure,
okay,
sure,
I'll respond directly to it. And
And you decided on A to omit.
I'm sorry.
Question 8, because it relates back to special 3, which we've taken out. It falls in the same category as number 2.
It's going to take me about 5 minutes to rewrite the instruction, and I will read it to you before I give it to the jury, and we will proceed.
Would it be possible to maybe have copies while you're reading it so we'd have it in front of us?
You know what? I'm basically, at this point, going to handwrite it out. I'm going to read it to you, then we'll reduce it to a typed copy. I'm not sending it to the jury room at this time. I want the jury to...
Yeah, just as long as we have not figured it out.
Okay.
Your Honor, one question. The court did indicate that it would give the language prohibiting dealing with brandishing and why it is not a sufficient basis for the 187 conviction.
Yes, I am, and I'm also going to incorporate your language that these are merely possibilities, and I'm not suggesting anything, and the jury is free to accept them or reject them. All right, thank you. We'll be in recess for about 5 minutes.
How long you're do you want us to...
Yes.
Does the, you want me to have somebody...
At some point.
And type that up for you?
No, I want to do it. I want to do this now. I want to knock it out, and then you'll do it at a later time. All right. The defendant's present with his counsel. The district attorneys are present. The jurors and the alternates are not present. I would propose and intend to read 520 modified as follows. The defendant is charged in count 1 with murder. To prove that the defendant is guilty of this crime, the people must prove that 1, the defendant committed an act with the firearm that caused the death of Lana Clarkson, such as placing the gun in her mouth or forcing her to place the gun in her mouth, at which time it discharged. pointing the gun at or against her head, at which time it entered her mouth and discharged, pointing the gun at her to prevent her from leaving his house, causing a struggle which resulted in the gun entering her mouth and discharging. By using these examples, I am not suggesting that any of these acts took place. These are inferences you may draw from the evidence, but are not required to do so. You may reject them. These are only possibilities that you may consider. The act committed by the defendant must be more than drawing or exhibiting a firearm in the presence of Lana Clarkson in a rude, angry, or threatening manner. And two, and then go on with the rest of the 520 instruction.
Could we ask you to read those?
Sure.
Would you mind reading it a little more? Absolutely.
Yeah, a little slower. Charge in count one with murder. To prove the defendant is guilty of this crime, the people must prove that 1, the defendant committed an act with a firearm that caused the death of Lana Clarkson, such as placing the gun in her mouth or forcing her to place the gun in her mouth, at which time it discharged, semicolon, pointing the gun at or against her head, at which time it entered her mouth and discharged, semicolon, pointing the gun at her to prevent her from leaving his house, causing a struggle which resulted in the gun entering her mouth and discharging. By using these examples, I am not suggesting that any of these acts took place. These are inferences you may draw from the evidence, but are not required to do so. You may reject them. They are only possibilities that you may consider. The act committed by the defendant must be more than drawing or exhibiting a firearm in the presence of Lana Clarkson in a rude, angry, or threatening manner. And then going on with the rest of 520.
May I be heard, Your Honor?
Absolutely.
Your Honor, we've argued other aspects of this. The court is going to give examples. We understand that. We've preserved our objections to them generally. But I have to make a specific to one clause of this that stands on a completely different level than any objection we've made to instructions thus far. And that is the phrase, or forcing her to place the gun in her mouth, end quote. That phrase simply must be deleted for these reasons. Quite broadly, there is probably not a single defense witness or a single prosecution witness who would have been called to testify in the way that he had, who would have been offered by prosecution ever had suggested at any point in this proceeding that Mr. Spector was guilty if Lana Clarkson was holding the gun in her own mouth. Would the defense have called expert after expert to say that 99% of interoral wounds are self-inflicted if it knew that the jury would consider a theory that the wound was self-inflicted while she was holding the gun in her mouth? Would the defense have called experts to say that the gun, the blood spatter on the gun, would have had a void on it if Mr. Spector was having it, but it didn't have that void? It was consistent with Ms. Clarkson having it, if it knew that the evidence that she was holding the gun would be offered to the jury, to a deadlock jury for the first time as proof not of innocence. We are talking about a situation to prove that Clarkson and not Mr. Spector is holding this gun. The prosecution argued the case on the theory it was Mr. Spector. They said they would prove beyond a reasonable doubt that Mr. Spector was holding this gun. And you're now offering them a theory under which they convict by finding it proved beyond a reasonable doubt that Ms. Clarkson was holding the gun. Would Mr. Spector have testified if he knew that all of his experts, all of his witnesses that pointed to Miss Clarkson holding the gun were in fact incriminatory witnesses, and the only way he could defend himself was by testifying that he did not force her to take the gun. Would the court have admitted any of the 1101B evidence if the theory was that, in fact, Miss Clarkson was forced to take the gun and put it in her mouth when there wasn't a single 1101B witness who testified that Mr. Spector ever gave them a gun or forced them to do anything with a gun? The identity of detail between the uncharged defense evidence and the prosecution's theory would have been completely absent. This court excluded evidence that Miss Clarkson sometimes willingly put guns in her mouth. It ruled it irrelevant. If the theory was that she was forced to put the gun in the mouth, then the court might well have to have ruled that that evidence was relevant. Your Honor, you cannot have a trial in which, after a jury is deadlocked, they are offered a theory under which every single piece of defense evidence becomes incriminatory. It's a violation. Your Honor, respectfully, I must say to you, you must excise that language from your examples. Any language which would suggest that this jury could convict on a theory that Miss Clarkson was holding the gun. If the people want to propound that theory, Your Honor, we need a new trial. It is the fundamental principle of American law that you are told before the trial begins what you must defend against, and we're in a position where this jury would now be able to convict Mr. Spector precisely because he effectively rebutted each piece of the prosecution evidence. I must ask the court to strike that phrase.
Well, thank you. I'll hear from the people, but once again, you're entitled to notice of the charge, the crime itself, not the theories. That is an incorrect statement of law. I'll hear from the people.
Your Honor, the last statement that the court included in its instruction, Mr. Brunon argued the exact same points that Mr. Reardon is now arguing, just at a higher decibel level. It's a reasonable inference drawn from all the facts, and it's a reasonable inference that one or more jurors could draw from the facts that have been presented. They're entitled under this instruction to what the reasonable inferences are that they can draw, and we're giving the defense the benefit and the legal benefit, I suppose, of taking away any possibility that they could convict based on a brandishing or some form thereof. The court has tailored and defined what the reasonable inferences are that they could draw from the evidence, and that's one of them. It's perfectly appropriate.
Could the court ask the people, or reiterate itself, what shred of evidence was offered in this trial that Mr. Spector ever forced, asked, persuaded, in any way caused another person to put a gun in the mouth? There's a complete absence of any evidence in support of that. I mean, there's not a shred of evidence to that. The only evidence that would support that is the fact that the gun was in her mouth, and if you're looking for any argument that would make him guilty, then he must have forced her, but that is speculative. And Mr. Reardon didn't articulate what the excluded evidence was from Ms. Gibson that would have specifically stated that Ms. Clarkson voluntarily put it into her mouth in a titillating way, suggesting that went against any argument that she was forced to put such an item into her mouth. I mean, this not only is it unsupported by evidence, it would have been refuted by available evidence that the court excluded.
Well, I disagree with that theory, and I'll give you what to me is a perfectly valid, rational inference to draw in a minute, but I'll hear from the people.
Your Honor, with regard to Mr. Brunon's comments, what evidence is there that he may have forced Ms. Clarkson to do anything? There is a plethora of evidence that Mr. Spector, when confronted with this type of emotional stimuli from other 5 other 1101B witnesses, forced struggles with some of those or all of those women. He forced some of them upstairs. He forced some of them to take clothes off. He forced some of them into a chair. He forced some of them to stay in a hotel room. He forced some of them back into the house. Though that is force, and that's force used with a gun. Given the circumstances and the inferences that can be drawn about what happened inside the foyer, this is not something that's unreasonable. It's perfectly reasonable that he could have forced Miss Clarkson to do any number of things, including put the gun in her mouth.
Your Honor, that's only half the picture. If you look at the cross-examination of the 1101Bs, each and every single one of them, all 5 of them, from Dorothy Melvin to the very last one, Deborah Robitaille, were asked questions by myself whether or not Mr. Spector ever forced them to touch the gun, whether Mr. Spector ever asked them to hold the gun, whether or not Mr. Spector ever asked them to place the gun against their head in any way, and most specifically, whether or not Mr. Spector at any time forced the gun in their mouth or asked them to put the gun in their mouth. Each and every one of those 5 1101B witnesses said no to all those questions. Uncontroverted.
It's a matter, the question is whether it's a reasonable inference that can be drawn from the results shown, and that's all that it is. The objection is overruled. Thank you. Anything further?
No, Your Honor.
Let's bring out the jurors and the alternates.
I just have one. I'm not a California lawyer, but there was one indication that brandishing under the California law, and you'll correct me if I'm wrong, hopefully I've learned a little bit, is that rude, angry, or threatening manner, or if done in a fight or quarrel.
But that's not, the fight or quarrel is not what we're shown in this case. That's another alternative.
Well, there is an indication of a struggle. I mean, so a struggle, if you're going to quarrel they were having.
If you look at the case law, I don't believe, and believe me, I've done.
If somebody pulls out a gun, sticks it in my face, yeah, there's gonna be a quarrel or an argument, yeah. But that came after. I think she was probably like, I'm going home, and he's like, no, you're not, and gun out. Because that's his MO. I don't think there was an argument before the gun came out. Maybe a disagreement, and then the gun came out.
Not applicable under the theory it's being used. I will be happy to quickly relook at it.
I believe only to see if I've learned anything in California law.
No, that is a different paragraph within the brandishing. Let me find the use note here. In the third paragraph of the bench note to 983, if the prosecution alleges that the defendant used the weapon in a fight, give alternative 2B. I don't believe that's what it is designed to be instructed on. If 2 people are fighting, you pull a gun. I don't think this is the facts of this case do not support that. One couple. Mr. Brennan?
The prosecution just argued that there was a struggle, and that's how she got the bruises on her arm.
I am fight that we are talking about here, one that clearly would not have been initiated or a mutual quarrel situation. If you look at the facts, if you have a case, Mr. Brennan, by all means.
It's not about cases, Judge. All of the interpretations.
Mr. Brennan, easy.
All of the interpretations the courts is drawing are going in one direction.
I did an episode. Who was it on? Dang, I don't remember. Oh, I forgot his name. It's like the second episode I ever did, so it's really bad. But the girl in the episode of Criminal Minds was setting fires, so it was about some guy, Peter. I don't remember. I want to say Sutcliffe, but I don't know if that's right or not. Anyway, a guy in England that set fires. He had OCD and he set fires. And that's what this girl did in the Criminal Minds episode. And I was like, no, I'm not talking about OCD like my husband puts away the canned goods when he gets home from the grocery store. And I took a picture of the pantry and how Travis puts the canned goods up. They all have to be together, green beans together, carrots together, peas together, and they all have to be facing with the labels out. And he had done it like the night before, and I ran and grabbed a pic of it and I put it in the episode, and it is a perfectly organized cabinet. And anybody that knows me knows I did not do that. It's beautiful.
Clarkson may have taken the gun. I mean, as long as we're speculating, that is no more remote than.
I don't know if it was alphabetical. Now I want to go back and look at that picture and see if it was alphabetical. I doubt it, because he's dyslexic. So I doubt it was alphabetical.
Mr. Spector forcing the gun into her mouth, or forcing her to place a gun in her mouth.
Would the people like to be heard?
Your Honor, it's not applicable. The entire reason that the court is trying to define this in terms of 520 is, I believe, to make sure that the jurors don't get misguided or misled, that they can use the exhibition of the firearm or the drawing or the exhibition of the firearm in any way, as opposed to the actual conduct that the court has laid out. I think it does exactly that with the way the court has already drafted the instruction.
Okay. While you call the jurors and the alternates, I'm going to go back and look at a couple cases and see if my theory is correct, or if you are correct. If you are correct, I will add the language. If I don't give it, then you know that I don't agree with you. Okay? All right. Let's bring the jurors and the alternates.
Court's been in session.
All right. Back on the record, all parties. The jurors and the alternates are now present, or the other parties are present. Ladies and gentlemen, I'm now going to attempt to answer the questions that you had the other day. I'm going to be reading some additional instructions to you, deleting an instruction, and hopefully that we'll be able to cover all the areas that you had concerns with. The question of whether the instruction should be one instruction, I think it was actually you were concerned with special number 3, and I'm going to instruct you on special number 3 in a second, but I just want to and I think this will also apply to another question that you had. I'm going to reread to you just from the very first instruction that I gave you, Calcrim 200. Pay careful attention to all of these instructions and consider them together. Answer question number 1. Your second question.
I'm the same way. I have organized bags for my diamond painting stuff and my cross stitch stuff and my knitting stuff and my crochet stuff. But my house is a disaster. And I need to quit chit-chatting so we can get through this.
Question concerns special instruction 3, and I'm going to get to that in just a moment. Your third question was whether in determining the weight of the evidence, the totality of the evidence should be considered, or the weight of one specific instruction. And again, I will instruct you from Calcrim 200 that you are to pay careful attention to all of the instructions and consider them together. Okay? I think that will answer your fourth question, which had to do with totality. Question number 5, whether you can view the clothing articles on a mannequin. The answer to that is no, for 2 reasons. Number 1, the clothing is no longer in the condition that it was when the relevant matters took place. And number 2, the clothing is not in evidence, and you may not view items that are not in evidence. The pictures are in evidence. There have been explanations given, and you are bound by that, so you will not be given the clothing that was not introduced into evidence to view. question number 6, the jurors are having problems with the concept of reasonable doubt, and I'm going to reread to you the reasonable doubt instruction.
But Jill, what if it's a where'd it go? Oh, I lost it. What if it's a series of books like Harry Potter and their sizes are different height-wise? Are you going to put them out of order on the shelf?
They moved when we changed instructions from what was then known as Cal Jur to Cal Crim, they moved the reasonable doubt instruction. I used to know right where to look for it. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt, unless I specifically tell you otherwise, with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. The next question you asked was whether it is appropriate for one juror to believe a fact is reasonable while another believes the fact to be unreasonable. In such a case, would that situation make the juror unreasonable? The answer is no. One juror finds the evidence and concludes that there is a reasonable doubt based on that evidence. That does not mean that juror is being unreasonable because others disagree with him or her. Each juror decides for themselves whether there is a reasonable doubt on any element or any other aspect where that is what you are applying. It applies to each juror individually. Of course, you talk to each other and you come to, you discuss matters, and you may decide whether or not a doubt is reasonable or possible or whatever, but the fact that one juror differs from the other, that does not make that juror unreasonable. Okay? The next question dealt with instruction number 3. I'm about to give you a special instruction on that, and that is as follows. This is now special instruction number 6. During our discussion yesterday, one or more of you sought clarification of an elaboration on the meaning of special instruction number 3. Upon reflection, I have decided that the other instructions I have given you adequately state the principles of law you are to apply in deciding this case. Rather than attempt to further explain special instruction number 3, I am withdrawing it. You therefore are to rely on the remaining instructions in your deliberations from this point forward. In withdrawing special instruction number 3 I do not intend to comment in any way on the correctness of the individual or collective opinions expressed by you in your deliberations to this point, nor do I intend to suggest anything about what opinions each of you should express or positions you should take in any further deliberations. In your deliberations from this point forward, do not consider the now withdrawn special instruction number 3 treated as though you had never heard of it. I'm also now going to read you, we're going to modify and have modified CalCrim 520, which is the instruction on murder. And I ask that you listen to it because the language is now different. And at some point, we will get you at least one corrected copy of the instructions. I don't know that I'm going to make individual ones available to you, but we will get these corrected copies of the instructions I am now reading to you into you. But you certainly, when I'm done, and I will have one further instruction to read after this, you may go ahead and begin your deliberations. The defendant is charged in count 1 with murder. To prove that the defendant is guilty of this crime, the people must prove that 1, the defendant committed an act with a firearm that caused the death of Lana Clarkson, such as placing the gun in her mouth or forcing her to place the gun in her mouth, at which time it discharged, pointing the gun at or against her head, at which time it entered her mouth and discharged, pointing the gun at her to prevent her from leaving the house, causing a struggle, which resulted in the gun entering her mouth and discharging. By using these examples, I am not suggesting that any of these acts took place. These are inferences you may draw from the evidence, but are not required to do so. You may reject them. These are only possibilities that you may consider. Defendant must be more than drawing or exhibiting a firearm in the presence of Lana Clarkson in a rude, angry, or threatening manner. And 2, when the defendant acted, he had a state of mind called malice aforethought. There are 2 kinds of malice aforethought: express malice and implied malice. Proof of either is sufficient to establish the state of mind required for murder. The defendant acted with express malice if he unlawfully intended to kill. The defendant acted with implied malice if 1, he intentionally committed an act, 2, the natural consequences of the act were dangerous to human life, 3, at the time he acted, he knew his act was dangerous to human life, and 4, he deliberately acted with conscious disregard for human life. Malice aforethought does not require hatred or ill will toward the victim. It is a mental state that must be formed before the act that causes death is committed. It does not require deliberation or the passage of any particular period of time. If you find the defendant guilty of murder, as a matter of law, it is murder of the 2nd degree. Finally, I am going to give you special instruction number 4, and this has to do with how you should now consider your deliberations. What I am now going to do right now, ladies and gentlemen, is have further instructions and directions to give you as to count 1. To assist you in your further deliberations, I am going to further instruct you as follows. Your goal as jurors should be to reach a fair and impartial verdict, if you are able to do so, based solely on the evidence presented and without regard for the consequences of your verdict. It is your duty as jurors to carefully consider, weigh, and evaluate all of the evidence presented to the trial to discuss your view of jurors in the court, your own views, or to request your fellow jurors to re-examine theirs. You should not hesitate to change a view you once held if you are convinced it is wrong, or to suggest other jurors change their views if you are convinced they are wrong. Frank and forthright exchange of views. As I previously instructed you, each of you must decide the case for yourself and should do so only after a full and complete consideration of all the evidence with your fellow jurors. It is your duty as jurors to deliberate with the goal of arriving at a verdict on the charge, if you can do so, without violence to your individual judgment. Both the people and the defendant are entitled to the individual judgment of each juror. As I previously instructed you, you have absolute discretion to conduct your deliberations in any way you deem appropriate. You may wish to consider changing the methods you have been following, at least wish to consider having different jurors lead the discussions for a period of time, having those on one side of an issue present and argue the other side's position, and vice versa. This might enable you to better understand the other's position. By suggesting you should consider changes in your methods of deliberations, I want to stress I am not dictating or instructing you how to conduct your deliberations. I merely find you may find it productive to do whatever is necessary to ensure each juror has a full and fair opportunity to express his or her views and consider and understand the views of the other jurors. I also suggest you reread CalCrim instructions. The integrity of a trial requires that jurors at all times during their deliberations conduct themselves as required by the instructions. CalCrim Instruction 200 defines the duties of a juror. The decision the jury renders must be based on the facts and the law. You must determine what facts have been proved from the evidence received in the trial and not from any other source. A fact is something proved by the evidence or by stipulation. Second, you must apply the law I state to you to the facts as you determine them, and in this way arrive at your verdict. You must accept and follow the law as I stated to you, regardless of whether you agree with the law. If any of the attorneys in their arguments or at any other time during the trial conflicts with my instructions on the law, you must follow my instructions. CalCrim 3550 defines the jury's duty to deliberate. The decisions you make in this case must be based on the evidence received in the trial and the instructions given by the court. These are matters this instruction requires you to discuss for the purpose of reaching a verdict. CalCrim 3550 is also an instruction which recommends how jurors should approach their task. You should keep in mind the recommendations this instruction suggests when considering the additional instructions, comments, and suggestions I have made in the instructions now presented to you. I hope suggestions may have some assistance to you. You're ordered to continue your deliberations at this time. If you have other questions, concerns, requests, or any communications you desire to report to me, please put those in writing on the form that my bailiff has provided you with. Have them signed and dated by your foreperson, and then please notify the bailiff. You may resume your deliberations at this time, and we will take the alternates back to their waiting area. 520, and if you'll take it and integrate it into 520.
We'll be happy to, Judge, and we'll also, I guess that's the only one that we have to.
It's the only one that needs
Judge,
to be.
if I could ask the court to ask Wendy maybe, I know all the jurors have the old version of 520, and they also have Special Instruction 3 in the deliberation room. I would ask that those be removed post haste.
Oh, that's right, to take from their copies.
Correct.
We've certainly told them to disregard it, but we will at some point attempt to collect them.
Thanks, Judge.
Okay? Anything else? Okay, thank you.
Thank you, Judge.
Yes.
One minor thing. If there's a note, is it possible, because we're going to go back to the hotel and all that, we could possibly know like what it is, maybe to delay the court not getting time consumed, that we could all talk before we get here so the defense team has some indication of how to respond. I know
Sure.
the other day, we didn't know until we got here, and I know we delayed the court by having to take our own meeting and stuff.
Well, the bottom line, you really didn't delay anything because you would have had to be here. It doesn't mean delay by having a meeting. I mean, if you're driving over from the car, which is 5 minutes along, because there's an issue, and usually I will tell you what the issue is. I deemed that I wanted the parties present before I discussed it with them, and I didn't even want to discuss it on the phone.
They have a thing of Mr. Reardon to get on the phone, and we'd like to talk
I understand,
before we get here.
and I will
Thank
try
you,
to
sir.
accommodate you if I can.
Appreciate it.
Okay?
Yay. Yay. We're going to finish. We're up to the decision. Which we know what it is, but I didn't think we were ever going to finish this trial. Okay, come on. They're going to keep us in suspense. Dun, dun, dun. 9 minutes. We got 9 more minutes. Oh yeah, Travis never gives me any problems either. And now that I'm stuck on my weight loss,
This court is now in session. The Honorable Larry Paul.
he'll eat lean cuisines. Like, he doesn't care as long as he gets fed. So I don't even have to worry about that. Although I do like to cook for him because I know lean cuisines are not the best in the world, and he can eat, although he doesn't eat near as much as he used to, but used to when he ate like even if I got a regular frozen dinner, I remember when I used to get HelloFresh, and I quit doing that. I just hate to cook. But anyway, when I got HelloFresh, he'd eat it and he'd like it, but then he'd go, well, that was just a tease. I need some more. But now his appetite has, I don't know if it's because he's getting older or I don't know, but he's lost some weight too because his appetite's not as big as it used to be. But yeah, because I was worried about it. I'm like, okay, look, I've got to lose some weight. I'm stuck. So we're going to eat frozen dinners. We're going to eat lean cuisines for a while. I'm going to do protein shakes and we're going to do lean cuisines. So yeah, he'll eat a lean cuisine, but it hasn't helped either. I don't know why I'm stuck. I guess my body's just, we're staying here. I don't know what's going on.
All right. The defendant's present with his counsel. The district attorneys are present. The jurors and the alternates are present. Juror number 10, I understand you have sent me a communication indicating that the jury is unable to reach a unanimous verdict.
Yes.
Is it your belief that there's anything that I can do further that has not yet been done to assist the jurors in any way?
No.
Without, again, indicating which way the jury is leaning, could you give me two numbers, please?
10 and 2.
10 to 2. How many ballots have you taken?
Total or just as?
Total.
6.
6. All right, I want to poll the jurors individually to see if any of you or all of you agree with juror number 10's conclusion. Juror number 1, do you think there's anything more that can be done that would assist you or any other juror in arriving at a verdict in this case?
No.
Juror number 2?
No, Your Honor.
Juror number 3?
No, sir.
Juror number 4? No, sir. Juror number 5?
No, Your Honor.
Juror number 6?
No, Your Honor.
Juror number 7?
No, Your Honor.
Juror number 8?
No.
Juror number 9?
No, Your Honor.
Juror number 10?
No, sir.
Juror number 11?
No, Your Honor.
Juror number 12?
No, sir.
Does anybody wish to be heard? Okay. No. At this time, I will find that the jury is unable to arrive at a verdict and declare a mistrial in this matter. The jury is discharged. Before I discharge you, there is a final instruction I need to read you, which is read in every case. This is the concluding instruction after the jurors have completed their service. You have now completed your jury service in this case. On behalf of all the judges of the court, please accept my thanks for your time and effort. Now that the case is, I remind you that under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about the case. Let me tell you about some of the rules the law puts in place for your convenience and protection. The lawyers in this case, the defendant, or their representatives may now talk to you about the case, including your deliberations. Those discussions must occur at a reasonable time and place and with your consent. Please immediately report to the court any unreasonable contact made without your consent by the lawyers in this case, their representatives, or the defendant. A lawyer, representative, or defendant who violates these rules violates a court order and may be fined. I order that the court's record of personal juror identifying information, including names, addresses, and telephone numbers, be sealed until further order of this court. In the future, if the court is asked to decide whether this information will be released, notice will be sent to any juror whose information is involved. You may oppose the release of this information and ask that any hearing on the release be closed to the public. The court will decide whether and under what conditions any information may be disclosed. What I'm going to ask you to do at this time, there are further things that we need to do. The jury commissioner needs to meet with you. The public information officer of the court is going to meet with you, and I'm just going to thank you personally. The jury room is too small to do that, as is my chambers. I'm going to ask that you all step into the jury room, including the alternates. I'll call you out again in just a few moments. So if you'll all step into the jury room at this time.
Your Honor, it sounded as if you said that the jurors cannot talk to the...
No, they may. If that's what it sounded like, it was wrong.
Okay.
No.
You said not.
You said not.
You may choose to discuss or not discuss the case with anyone. No, you certainly can, and I believe some of the jurors may wish to meet with you, so I apologize for that. Would you all, including the alternates, go ahead and step into the jury room at this time? We'll buzz you out shortly. Just go ahead and step in the jury room. All right, the jurors and the alternates have left the courtroom. Have the people come to any conclusion as to how they wish to proceed with this matter?
Well, we think it should be set for a hearing in the near future.
Okay.
I have a recommendation that I'd make to the court. This is a suggestion. Maybe I could confer with Mr. Jackson, Mr. Dixon for a moment. We could pick a date, maybe 60 days out, set it for whatever you prefer, either a status conference or a pretrial at that time. It would give both sides an opportunity to reconnoiter and regroup and figure out where we are on this. Seems to make sense to me.
I think 60 days is that's way too long. I'm thinking perhaps a week or 10 days sometime within the next 2 weeks.
Well, may we approach for a moment on that?
You may approach.
Judge, with that clarification, I think that we can advance my suggestion to a date next week. And
I would suggest Wednesday, October 3rd.
with his calendar and see how he's doing on that day. You're suggesting Wednesday the 3rd? That's right. That's fine with me.
Is the second?
The second is fine.
Second's not good with me.
All right. I don't want to go beyond.
I'll make the 3rd.
All right. At 10 o'clock, would that?
That's fine.
All right. The 3rd at 10 o'clock for further proceedings to set dates as necessary, whether that becomes necessary to discuss calendaring, if that becomes necessary.
If it's acceptable with the court, since it's going to be a lot of housekeeping matters, I'd like to waive Mr. Spector.
He doesn't have to be present.
Thank you.
Now, let me explain what we're going to be doing. Because of the size of the jury, I'm going to meet briefly with the jury just to thank them. They need to meet with the court information officer. They need to meet with the jury commissioner. These are not public proceedings. These are matters. The public proceedings are basically terminated at this point, but I want to be able to use the courtroom because of the size and the number of people that will be present. I'm going to clear the courtroom. We will talk to the jurors, tell them, as I have already instructed them, they can talk to anyone. If any of them wish to speak to the media, I believe some arrangements have been made. If not, we're going to tell you that. I believe I'm going to ask the lawyers, though, I'm going to clear you out of the courtroom, but I'm going to ask that you remain close because the jurors may wish to speak with you, and I want to be able to bring you back. So with that in mind, that's the public proceedings matter. By the way, orders as to parties and witnesses remain. There is to be the same as it was during the trial until we see where we're going. So all previous orders are in full force and effect.
We just have one quick before you two.
All right, thank you. Thank you. Yes.
In light of the court's ruling just now.
Quiet, please.
Mr. Taylor, this concerns you, I want to say. Because we're under a continuing gag order and a no dissemination order, could the court either deny the proposed order that's pending or at least hold it under submission? Issues and serious scope issues involving some of the items that the court didn't assist us in obtaining, particularly. I'm talking about the order submitted by Mr. Taylor, if I haven't been clear. Given the fact that the court has ordered us not to discuss the matter nor to disseminate any information to the media, I think that the proposed order is unnecessary at this point.
Well, what I'm going to do is sign the order, but it is subject to modification, and it does mean that you're precluded from raising any issue or bringing it back to the court's attention whenever it's necessary.
All right, just one point of clarification. We have, until this point,
Okay, I'm done. We did it! Yes, we are very blessed that Judy is still here. Yay! Guys, we did it! We did it! We did it! Yay! We're done with the Phil Spector trial. Yay! So, let me double check the poll. I think we're going to do Betty Broderick. Yep. Betty Broderick is our next one. This woman, this happened, I want to say this happened in the 80s. It could have been the 90s, though. The 80s and the 90s are like, the late 80s, early 90s are a blur for me because I got glitter everywhere. The 80s and the 90s are a blur. The late 80s, early 90s, because I graduated in 87. I started college in 88, and I wanted to wait a year, and my parents wouldn't let me. So I basically, it was too soon. Like, I wasn't ready yet. So I had a lot of trouble. At first, I loved it because it reminded me of high school because I went to a community college, so it was a small school with small classes like I was used to in my high school. But then the work was harder, and while in nursing school, I was a straight A student, but that's the ADHD, and we didn't know back then that I had it. And so the hyper focus on the nursing, that, because like people with ADHD, they're scatterbrained when they're not like super interested in stuff, but if they're interested, they hyper focus on it, and they can concentrate, and they can be super receptive to that information. So nursing school, straight A's, like no problem at all. But the other stuff that I had to learn to get into nursing school, the prerequisites, I did not do so great on. So I ended up dropping out of college. So then they let me skip a year. So I graduated in 87, went to college in 88, dropped out in 89, worked for my mom. My mom, had a daycare, so I worked for her, and then my mom died in 90. So I went to nursing school in 90. I went to LPN school in 91, graduated in 92, started working as an LPN in 93. So from like 87 to 93 is just a huge, huge, huge blur. Didn't who have children in prison? Betty Broderick? No. She had, well, when all this started, I thought her kids were younger, like teenagers, or even younger than that. Unless I'm remembering wrong. She put her husband through medical school. I think it was med school. And then he got his own practice, and then he started having an affair with someone he worked with, one of his nurses or his office manager or something like that. And then he was supposed to pay her alimony, and it was like a huge amount of money monthly. And she said she couldn't live on that. That was just her alimony. That was not the kid's child support. That was just her money, and she said she couldn't live on that. And she just, the things this woman did, like the petty, I don't know if all that's going to come out in the trial. I should do an episode on her because, I mean, they made a TV movie about this lady and Meredith, what was her name? I know Judy can help me with this one. Meredith Baxter Barney, was that her name? She was the mom on Family Ties. She played Betty Broderick in the TV movie. This woman, like, she lost it when this man left her. She went crazy. I mean, like, she could not function without this man. She just lost her mind. Lost her mind. And then I watched, like, just a clip of her on the stand not too long ago. Maybe like a year or so ago, and I was like, oh my God, the behavior panel needs to watch this and tell us, because this woman is just nuts. Like, she's like flirty and laughing and stuff on the stand. Like, she's insane. So I've been wanting to watch, actually, no, that's probably a couple years ago, because I've been wanting to watch this trial for a while. And then, but I wanted to watch Phil Spector because of AJ being in it and because of the Karen Reed trial and all that. So yeah, now we get to do Betty Broderick. Yay. But yeah, that woman, I feel for her, you know, like I feel sorry for her because she put her husband through medical school. And when you get married with the expectation that I love this person, I'm going to be with them forever. So yes, I'm going to help them. She had 4. I don't know why I was thinking she only had 2. 4. See, that's the thing. I don't get it. Like, what overrides your maternal instinct? That's why I said, like, she went crazy. Like, she left her kids at home to go do stuff to them. Like vandalism and all kinds of crap. Until one day she went over there with a gun. But yeah, like you have the expectation when you get married that this is forever. So thinking, yeah, I'll work hard and put him through medical school and then he'll take care of me for the rest of my life. That's a valid thought to have. And you don't expect them to then cheat on you and divorce you later after you've put them through medical school. I get it. But don't go crazy. Your best revenge is to go on and live a good life. That's your best revenge. But this lady went cray-cray. Absolutely cray-cray. So this should be a fun one too. This one had a lot of boring parts to it, but overall, I found it very interesting, especially the part about Dr. Henry Lee, because he's always kind of been held up as this great forensic scientist that's like the father of forensic science and everybody should bow down to his knowledge, and no, not anymore. I don't hold him up on a pedestal at all anymore. And with the hung jury thing, with what Judge Fiddler did, like, I didn't expect that at all. And he never did give him an Allen charge either. He just told them, okay, well, we'll look at the jury instructions and we'll come to some decisions and we'll let you know. Which I thought that was great, that he was able to have a dialogue with them about what they were confused about. I would have loved to see Bev do that, because if she had done that, we probably wouldn't have had to have a second trial. Well, maybe on the one they were hung on, but at least the other 2 would have been off the table. But so I'm hoping there are parts of her trial on YouTube, but I don't know if all of it's on YouTube. So if you guys don't mind using the stupid Court TV website again, it's okay with me. But I do want to watch her trial, so yay. Okay, so what I want to do now, and I have it set to portal you guys to the next stream. The judge and the attorneys talked a little bit this morning before jury selection started in the Donna Adelson case. And then there are some older hearings that we have not listened to or watched, whatever. And there's also a pretrial, like a few days ago was a pretrial hearing, like the last pretrial hearing. Which we'll probably do that one tomorrow, because I don't know. I didn't plan this. I mean, I planned. You didn't expect me to plan anything, did you? I planned. I loosely planned, okay? I didn't intricately plan anything. We're just going to watch old hearings, and when I get done, we'll be done. So, Porter, you over there. I will see you guys over there in a few minutes.